Let's go ahead and start the hearing. Before I go on the record, I just want to make a quick announcement again for all the council in the room, and I'll make this again on the record. We do not have a live or on WebEx court reporter today. We're still working on getting one for tomorrow, but that also does not look positive. We will have a live court reporter, Ms. Bench, next week. We, the commission, are making 2 recordings of today and tomorrow, and we will be then transcribing those. We are aware of some of the technical issues that we had with yesterday's opening statements and also with the securitization case? I think so. So we have worked to correct those, and we'll obviously all be looking at the transcripts for today and tomorrow. There are provisions in the commission's rules for correcting the transcripts, but just to give everyone a heads up. That said, I'm really sorry. I'm probably going to have to interrupt everybody today to remind everyone to talk slowly and into a microphone. So with that, let's go on the record. Today is September 1st, 2022, and the Commission has set this time aside to continue the hearing in the Evergy Metro and Evergy West general rate cases. I will only read the case numbers as this is a continuation of yesterday's hearing, and that is file number ER-2022-0129, and that is related to Evergy Metro Incorporated, and file number ER-2022-0130, and that is related to Evergy Missouri West Incorporated. For the record, Commissioner Coleman is on the WebEx, as is our chairman, Ryan Silvey, and that is Maida Coleman, M-A-I-D-A, and Silvey is S-I-L-V-E-Y. Let's get to the couple preliminary matters. I've already informed everyone in the room and on WebEx we do not have a court reporter today. We will all be making a conscious effort to talk slowly and into the microphone, as the court reporter will be transcribing this later. Also, the presiding officer was notified of Mr. Clody's needed absence today, and that has been excused. Let's go to introduction of parties. We already have everyone's address, so to make this a little easier for our future court reporter, let's just do companies and names today. Let's go for Evergy Metro.
Judge, appearing for Evergy Metro and Evergy West, Roger Steiner, Jackie Whipple, Carl Zobrist, Jim Fisher.
Thank you, sir. And for staff?
Appearing on behalf of staff, Nicole Mers.
Thank you. And for OPC?
John Kleiser.
Excused, but I'll call to, just in case, Charge Point. And Google? MECG?
Tim Opitz for MECG.
Excused, but I'll call anyway, MIEC. Renew Missouri.
Elisa Greenwald for Renew Missouri.
Thank you. And excused, I'll call anyway, Sierra Club. And then our 4 parties that are interveners into the Evergy Missouri West case, and that is the file number that ends in 0130. Excused, but I'll call City of St. Joseph. Dogwood Energy. Nucor Steel.
Mark Ellinger for Nucor Steel.
Velvet Tech Services.
Stephanie Bell for Velvet Tech.
Thank you all. That will take care of our introductions. And as I understand it,
Hey,
we
Judge,
yes, Commissioner Holzman.
just want to let you know that I've joined. Thank you.
Thank you. I appreciate that, Commissioner Holzman. I do expect the other commissioners will be joining us later as well. Let's go to our mini opening statements. And we will start off with Evergy.
Good morning, Judge. May it please the Commission, Carl, K-A-R-L, Zobrist, Z-O-B-R-I-S-T. I'll be giving the mini opening statement with regard to the Sibley issues. I believe it's Section 2 of the Commission's order. The 3 power plants at the Sibley Generating Station were built in the 1960s by Missouri Public Service Company, the predecessor of Evergy, Missouri West. They were all coal-fired units originally designed to burn high-sulfur Midwestern coal. Unit 1 at 48 megawatts was built in 1960 and was retired in 2017. Its retirement is not an issue in this case. Unit 2 at 51 megawatts was built in 1962 and began service in that year. Unit 3 at 364 megawatts was built in 1969 and began service in that year. The issue today is whether the retirement of Unit 3 in 2018, along with the smaller Unit 2 and the balance of the Sibley Station, was prudent. Given the many factors that were involved in that decision, the company believes that it was. Staff does not disagree. Only public counsel has filed testimony alleging imprudence. Your decision on this issue requires some understanding of what got us to this point, so a short history lesson will follow. In the late 1980s and in the early 1990s, in response to increasing environmental regulation and the price of coal, the Sibley Station and these 3 units underwent substantial life extension measures and a coal conversion project that would permit them to burn low sulfur, low ash, Wyoming Powder River Basin coal. These changes are well documented in the Commission's decisions in 2 major MOPUB proceedings, case number ER-2022-0129, decided October 5, 1990, and case number EO-91-358, decided December 20th, 1991. As these plants moved into the 21st century, it became clear that they would face more challenges with additional environmental regulations regarding nitrogen oxide, mercury, ozone, and other emissions. In addition, after FERC's, and that's F-E-R-C', Seminal Order 888 in 1996, and Order 2000, access to the transmission grid was opened and wholesale electricity markets were formed. These allowed utilities to sell and buy power at market-based rates that would benefit the utilities as well as their customers. Evergy, Missouri West and Evergy, Missouri Metro belong to Southwest Power Pool and participate in its competitive markets as you have authorized them to do. More significant was the recognition that carbon emissions at long last were having a negative effect on the environment and that something needed to be done. While studying these developments, the company made necessary environmental upgrades to Sibley in 2008 and 2009, which caused its depreciable life on paper to extend to 2040. However, in the context of these national trends, the way that electric utilities in Missouri and across the country did business began to change dramatically. With the advent of renewable energy resources, primarily wind generation and solar generation, utilities began to retire their old coal plants in record numbers. As Evergy's Vice President of Regulatory Affairs, Darren, D-A-R-R-I-N, Ives, I-V-E-S, describes in his rebuttal testimony, 10 years ago, in 2012, the company's integrated resource plan showed that units 1 and 2 should be retired in 2017 as part of its preferred plan. The company was then known as KCP&L, Greater Missouri Operations Company, which I'll refer to as GMO. In 2015, GMO publicly announced that Sibley 1 and 2 would stop burning coal by the end of 2019. Although, as I mentioned, operational issues would cause Sibley 1, except for its boiler, to close in 2017. So that brings us to the 2017 annual update of the company's Integrated Resource Plan, or IRP. 2017 is the critical date for the Commission to focus on as it analyzes whether the decision to retire Sibley in November 2018 was prudent. On June 1, 2017, GMO filed its annual update of the IRP with the Commission. It showed that Sibley 3, as well as Unit 2, should be retired at least by 2019 because all the modeled scenarios, including 3 levels of natural gas prices, 3 levels of load growth, and 2 levels of carbon pricing, showed that retiring Sibley would save customers approximately $220 million on an expected value basis. Both Mr. Ives and Evergy's Vice President of Strategy and Long-Term Planning, Kayla, K-A-Y-L-A, Messamore, M-E-S-S-A-M-O-R-E, discussed this in their rebuttal testimony. Given the clear results of the 2017 IRP annual update, as well as Sibley's performance in the SPP energy markets, the company announced in June 2017 that Sibley 3 and 2 would be retired by December 31, 2018. Now, in the fall of 2018, events occurred that govern this case. That was the company's plan to retire Sibley 3 at the end of 2018 until it was forced offline by a turbine vibration on September 5, 2018. The company made the required EFIS filings with the Commission on September 6 and September 12 regarding this event. An investigation of the turbine vibration and the damage it caused concluded that it would cost $2.21 million to repair Unit 3. Because it was already scheduled to be retired by the end of 2018, the company decided to retire Unit 3 and the rest of Sibley on November 13th, 2018. Now, at that time, as Chairman Sylvie and Commissioners Coleman and Roop will recall, the Office of the Public Counsel and MECG filed a petition for an accounting order at the end of December 2018. And they asked the Commission to find, first, that the retirement of Sibley was an extraordinary event under the accounting rules of the FERC Uniform System of Accounts that the Commission follows. And secondly, to issue an accounting authority order, an AAO, that established a regulatory liability to record A, the revenue collected in rates for the return on Sibley plant investments, and B, its non-fuel operations and maintenance costs and other costs. That was an accounting case. It was not a prudence case. Pursuant to the Commission's decision in October 2019 in that matter, the company established an AAO and accounted for the Sibley revenues and costs in a regulatory liability. And in this case, the company has advised that the regulatory liability now consists of two elements: $39 million in non-fuel O&M expenses. And Mr. Cloak discusses this in his rebuttal testimony, and $49.5 million in revenues. The company proposes that the $39 million should be amortized and returned to customers over 4 years. These are what we call the O&M costs. This matches the 4-year period over which the revenues were collected in the AAO accounts. However, it's Evergy's position that the $49.5 million in return on investment should not be subjected to the same refund as the deferred O&M costs, given that the company met the criteria of the prudence standard when it retired Sibley in 2018. Your decision in the AAO case has no bearing on whether the company's decision to retire Sibley was prudent, as the report and order in that case stated at pages 13 and 14. GMO chose to close the Sibley units, and the prudence of that decision is not an issue in this case. The question of prudence will be addressed in a future general rate case. That is this proceeding where the prudence of the Sibley retirement decision is to be decided. The Commission's review of the facts must include not only the 2017 IRP annual update and its assessment that customers would save $220 million on an expected value basis, but also the operational and economic performance of Sibley. As Ms. Messomore's rebuttal testimony stated, quote, "Sibley was in no way profitable," end quote. There were months when Sibley's energy revenues did not even cover its fuel costs, and that is without regard to its O&M costs and its capital costs. In 2018, when Sibley was retired, its energy revenues were $26 million. Its fuel costs were $23 million, and its non-fuel O&M costs were $29 million. That was a net loss of $26 million. And that was also before any of its capital costs were considered. In November 2017, when Evergy met with staff to discuss the company's capacity planning, Sibley had revenue margins of $5 million year to date, compared with O&M costs of $28 million per year. Sibley's margins over the 3-year period of 2015 through 2017 were only about $4 million. But the company's forecasts showed that to keep the plant running, it would take future capital investment over the next 4 years, 2018 through 2021, of $54 million and O&M costs of $111 million. That's a total of $165 million. Given Sibley's unprofitability as an old coal plant, its operational record, the cost to repair the turbine at Unit 3, and Evergy's commitment to renewable resources and a cleaner environment, the company's decision to retire Sibley in 2018 was prudent. It was also consistent with national trends as electric utilities across the United States had been and were continuing to retire coal plants. Larry Kennedy, a utility asset and depreciation expert with Concentric Energy Advisors, has provided testimony that confirms this. In particular, he notes that simply because Sibley had a depreciable life extending to 2040 doesn't mean that the decision to retire was imprudent in light of other facts. The prudence standard is important in this case. That is the test that the Commission has applied for many years to determine whether utilities' decisions were prudent It is a simple and straightforward test. It asks, was the company's conduct reasonable at the time under all the circumstances, considering the company had to solve its problems prospectively rather than in hindsight? That's the test that the Commission established in the Union Electric Callaway nuclear plant back in 1985. And by not using hindsight and by not considering events that occurred after the retirement decision, the Commission does not place a utility in the impossible position of having to foresee the future and anticipate unusual and anomalous events. For example, in deciding whether the company's decision to retire Sibley in November 2018 was prudent, the company does not consider what happened over 2 years later in February 2021 when Winter Storm Uri struck the Midwest. Similarly, we don't consider the effect of the Russian invasion of Ukraine on the price of natural gas or other fuels. And we don't consider the fact REOs are now discussing whether to pay through reliability must-run contracts to keep old coal plants online. We don't consider those factors. As Concentric's John Reed testifies in Seattle, the retirement of Sibley was consistent with Evergy Missouri West's resource planning and was prudent by any reasonable application of the prudence standard. Let me now go to the cost recovery and depreciation issues. Because the retirement was prudent, the company is entitled to the recovery of the undepreciated plant balance associated with Sibley, as well as entitled to earn a return on that investment. Evergy Missouri West should also be allowed to recover and earn a return on the prudent decommissioning and dismantling costs of the Sibley plant, which served customers for almost 60 years. John Spanos, president of Gannett Fleming and a nationally recognized depreciation expert, has provided testimony on these issues, as had Mr. Kennedy. So the 3 points that I want to discuss in the context of these issues. First, net book value. There is some disagreement over the exact figures regarding the recovery of the net book value of the Sibley plant. Mr. Spanos recommends a net book value of $145.6 million for Sibley based upon historical recovery patterns of the plant while it was in service. This figure was calculated as of June 30, 2018, based on the known life parameters of Sibley, not through mass plant accounting for all generating facilities, as has been done in the past. Staff accepts this $145.6 million net book value figure. MECG and Public Counsel have argued for a higher net plant balance of $300 million based on accounting schedules developed using the simple allocated reserve methodology historically used in the company's plant accounting system. Evergy had informed the parties for years, including in the 2018 rate case, that except for the relatively new Iatan 2 unit, the company's accounting system did not maintain generation reserves on a unit or location basis other than by a simple allocation process. However, during the last depreciation study that was performed in case number ER-2016-0156, that we'll refer to as the 2014 depreciation study, the approved depreciation rates were based on the lifespan approach and the remaining life methodology. Once the lifespan and the remaining life methods were approved by the Commission, the development of depreciation rates at the local and unit level were calculated based on these key parameters for establishing the appropriate accumulated depreciation by location and by plant. Therefore, for the June 3, 2018 development net book value for Sibley and for other locations was calculated in the same manner with the appropriate life parameters known at that time. Consequently, the depreciation rates by unit or location developed in 2018 by Mr. Spanos and his firm were a continuation of the methodology used in case number ER-2022-0156 with the more accurate historical parameters by location. Mr. Spanos has reflected the appropriate unit and location reserves in his 2022 depreciation study in this case. And he will describe why his approach to develop unit and location reserves is appropriate. His study supports the $145.6 million net book value for Sibley, meaning its net unrecovered balance. Point 2, the staff offset. Staff proposes to offset the net book value of Sibley by 2 items. First, deferred depreciation expense, and second, the regulatory liabilities recorded for the non-fuel O&M expense, that's the $39 million, and Sibley rate-based returns recovered in rates. Evergy agrees with staff's offset of the deferred depreciation expense, and Evergy agrees with staff that the $39 million regulatory liability for non-fuel O&M expense be amortized and returned to customers over 4 years. However, Evergy disagrees with the offset of the $49.5 million regulatory liability because the undepreciated book balances were prudently incurred as the decision to retire Sibley was prudent, given that it was no longer economic. And because the funds invested in Sibley were made on behalf of customers, Evergy Missouri West is entitled to earn a return on those prudently incurred investments. So in summary, the $145.6 million net book value as of June 30, 2018, which was determined by Mr. Spanos, reflects the most appropriate calculation of the net book value associated with the Sibley assets, which Evergy Missouri West should be able to recover and on which it should be able to earn a return during the recovery period of 20 years. Point 3, dismantlement costs. The company incurred approximately $37 million to commission and dismantle the Sibley station, which has been completed. These costs have been recorded to the steam production reserve accounts pursuant to the FERC Uniform System of Accounting requirements, appropriately included by the company and staff in rate base. The recovery of these costs from customers through their being included in rate base and through prospective depreciation rates is reasonable and necessary, given that the Commission has historically approved and continues to approve depreciation rates that do not include recovery for terminal net salvage value. Public Counsel and MECG would have the Commission provide no return to Evergy on these expended costs. That would be both unjust and unreasonable, as these costs have not been provided for in depreciation rates and reflect the prudent and necessary costs of dismantling the Sibley station. The company urges the Commission to accept the figures of Mr. Spanos and his comprehensive depreciation study for Evergy Missouri West and to inquire of him regarding any questions that it may have. Mr. Kennedy from Concentric, as well as Darren Ives and Kayla Messamore will be here and available to answer questions that you may have. Finally, a word about gaming. The evidence in this case shows that Evergy faced a variety of issues regarding Sibley and that it made its decisions based upon a review of the facts which existed at the time that these decisions were made. Those decisions relied upon the sound judgment of engineering, operational, financial, and regulatory professionals at the company. They also relied on highly qualified outside experts on depreciation, like Mr. Spanos. A fair reading of all of the facts shows that far from pursuing a devious plan to game the system, the company made decisions that balanced the interests of Evergy's customers and Evergy's investors over the long term, almost 60 years in the case of the Sibley Generating Station. Any suggestion to the contrary is rooted in pure polemics and is a distraction from the complicated issues the Commission must decide in this case.
Thank you. Are there any commission questions for Mr. Zobrist? And I'd also like to state for the record, we are joined by Commissioner Kolkmeyer, and that brings my total, if I am correct, to 4 of our commissioners thus far. We have Chairman Ryan Silvey, Commissioner Maida Coleman, Commissioner Jason Holzman, and Commissioner Glenn Kolkmeyer on the line. Thank you, Mr. Zobrist. We'll move on to...
Hey, Judge.
Yes.
Judge, Commissioner Root's here as well. I don't have any questions.
Thank you, Commissioner Roop. I appreciate your letting us know. Let's move on to staff's opening statement. And please remember, state your name first and speak slowly into the microphone. Thank you.
My name is Nicole Mers, and I represent the staff. Good morning. May it please the Commission. Given the court reporter issues we're having, I'm going to keep this brief, but I am available for any questions that may come up, and Keith Majors and Cedric Gunnigan will also be here on behalf of staff to answer questions. As you heard from Mr. Kevin Thompson yesterday, staff is a neutral party in commission proceedings. Staff does not advocate for the company, nor does staff represent ratepayers. Staff does not develop positions with a specific outcome in mind, and it does not back into evidence to come to a particular result. Staff audits, analyzes, and reviews information provided by the utility, parties, and staff witnesses use their expertise and training to apply techniques and procedures to arrive at a conclusion based on the evidence in the record. Staff's position on Sibley highlights this. Staff occupies a Goldilocks spot between the company, OPC, and MECG. Staff recommends a value of $145.6 million of unrecovered investment for Sibley. This value should be offset regulatory liabilities that were approved in the last rate case, which was ER-2018-0146, and the EC 2019-0200 case that resulted in the AAO. Therefore, a value of $39 million updated for FAC adjustments, and that was related to labor and non-labor operations and maintenance expense, and that should be used to offset the $145 million unrecovered investment. Staff also recommends that Evergy share in the risk of retiring Sibley early with customers by allowing return of, but not return on, Sibley. Sibley is no longer used and useful, and in this recommendation, staff is not penalizing Evergy by recommending no return, but we're simply recognizing the undeniable fact that Sibley is not providing any benefits to customers and that all new replacement generation costs would be borne by ratepayers. Therefore, a sharing of unrecovered Sibley investment is equitable. This sharing can be accomplished in 2 ways. First, the Commission could offset the regulatory asset by $449.5 million of rate of return that was deferred in a complaint case. Or the Commission could choose not to include the net book value of Sibley in rate base. If they choose this approach, the Commission should consider not including then the $49.5 million of return in that rate that was a regulatory liability set in the complaint case. Finally, the last step for calculating the appropriate amount of Sibley investment to return and recover in rates would be including decommissioning cost of $37.5 million. These costs should be added to the net book value determined by the Commission and then also should be removed from rate base. So when you put all of these steps together, this results in staff's recommendation of an amortization of the residual regulatory asset of $6.1 million and the cost of service over 5 years. Now, you'll hear about the different values that parties are presenting in this case. This disagreement between staff and the other parties results from the differences in calculating the net book value of Sibley. All parties present different values for this amount. This is partly due to the difficulty in calculating net book value, as there is no data included in an EMS run from prior rate cases that gives the exact value for Sibley. This was also an issue in the EC 2019-0200 case, where no definitive net book value was decided at the time. If the Commission approves the global partial stipulation, calculations such as this will be easier going forward, as the company has agreed to record and track depreciation reserve for generating facilities on an individual unit and location basis going forward. However, in this case, the Commission still has to determine the value based on what evidence the parties presented. Staff's $145.6 million figure results from witnesses Keith Major's audit of expenses and rate base related to Sibley, and Cedric Cunningham
evaluation of the appropriate depreciation rates. Staff's ultimate recommendation of $6.1 million is the only one that recognizes Sibley is a plant that was built in 1960, so has been in service and depreciating since then. But that plant no longer provides any benefits for ratepayers. Both witnesses, as I mentioned earlier, will be taking the stand later to explain and can answer any questions. In this case, Evergy is the only party requesting the return on the investment. Both MECG, OPC, and staff oppose this request. Plant that is not used and useful should not earn a return. Doing so violates long-standing commission and general regulatory practice, as well as 393-135. Thank you, and I'm available for any questions you may have.
Thank you, Ms. Mers. Are there any commissioner questions? Hearing none, we'll move on. Our next opening statement is MECG. I think it was cross-exam that we changed the order, but I have not changed the order on opening statements.
That's fine. Me, thank you, Your Honor.
Okay, let's go ahead, Mr. Opitz, and slowly and into the microphone for our future court reporter.
Thank you, Your Honor. Tim Opitz, O-P-I-T-Z, on behalf of the Midwest Energy Consumers Group. I just want to say before I begin that I heard that the net book value was not included in the accounting schedules of the last case for Sibley, and I disagree with that. I think Greg Meyer's testimony shows where it was included, and I think that the commission staff's witness, Mr. Majors, has testified that that value was included in the last rate case. Next slide, please. We can, next slide, please. This is background on Sibley. Basically, it was retired formally after the true up of Evergy's last rate case, but before rates became effective in that case. Essentially, that means rates from that case were revenues, costs, and investments as of a true up date of June 30th, 2018. Since Sibley Units 2 and 3 were formally retired after that date, Evergy's current rates include the costs, revenues, and investment associated with the Sibley units. Next slide. Because that retirement happened, MECG and OPC sought a complaint, EC 2019-0200. And they sought an AAO for the capital and operating costs that were included in Evergy's rates for the Sibley units, based on the principle that a utility should not earn a return on plant that is not used and useful or benefiting customers in any way. The commission granted that AAO, and in our view was very clear about what the amount of that AAO should be. Next slide, please. This is an excerpt from that report and order. KP&L Greater Missouri Operations Company shall record as a regulatory liability in account 254 the revenue and the return on the Sibley unit investments collected in rates for the non-fuel operations and maintenance costs, taxes, including accumulated deferred income taxes, and all other costs associated with Sibley Units 1, 2, 3, and Common Plant. MECG's witness Meyer, his direct testimony, rebuttal and surrebuttal reflect that our position is just that, consistent with that order. What he did was he referred to the staff's accounting schedules from the last rate case, ER-2022-0130, to find the undepreciated balance for the Sibley units, because that was what was used to develop rates. Next slide, please. That value is approximately $300 million. This is shown from that 2018 case to reflect both the staff's and the company's true-up accounting schedules that was used to set rates. When Greg Meyer updates that reserve from the time of that case up through the effective date of rate, expected effective date of rates in this case, that's where he gets his balance of $254 million. Next slide, please. In its rebuttal testimony, the staff recognized that that was an appropriate value. Witness Majors said, "I can conclude that the NBV of $300 million is the amount upon which the AAO return on deferrals should be calculated, as that amount was the basis of the rate of return and depreciation calculation." I'm not sure how, if staff can calculate that as what is in rates, how their position of 145 unrecovered investment is consistent with that commission's order. Next slide, please. The company's testimony, as counsel for the company pointed out, is offered by witness John Spanos. And he, in his surrebuttal testimony and direct testimony, clearly states that the commission should approve the recovery related to Sibley presented in their depreciation study as of June 30th, 2021. A couple notes about that. That calculation was done after the fact when rates were set. It was done in response to, it's my belief, it was done in response to the complaint brought by OPC and MECG. Commission, in that AAO, you did the right thing. You said that the plant was not being used for customers. You saw that it was retired after the rates were set. And you said create a regulatory liability for it based on what's in rates. MECG's figures are based on what's in rates. The staff agreed. The company, on the other hand, says rely on this new study and not what's in rates. Next slide, please. And the impact of adopting the company's position, Commission, is that it permits the company to earn a return on plant that is not used and useful or benefiting customers in any way. MEC's position is that is wrong. I think that there is legal reason to believe that that would be an illegal order if the commission were to permit the company to earn a return on that. I'm happy to address that further in briefing. I'm happy to answer any questions and would ask the commission, if anything is unclear, that Greg Meyer is available today to answer the specific accounting details or any questions about that.
Excellent. Thank you, Mr. Opitz. Are there any commissioner questions for Mr. Opitz? Hearing none, we will move on in opening statements, and I may need to pause here and look around the room. Are there any other parties intending a mini opening statement regarding Sibley? Any others?
No, Judge.
All right, let's go to the Office of the Public Counsel. And as I have reminded everyone, please speak slowly for our future court reporter and into the microphone. Thank you, sir. Please go ahead.
I will endeavor to go much slower than yesterday. So, may it please the commission. The fun part about going last is that, you get to hear everybody else's openings. So this nice little script that I wrote up yesterday, I immediately have to go off script for just a moment. Because I want to address something before we really get into the meat of it, which is we shouldn't be here on this issue. We should not be sitting in this courtroom today discussing this issue because Sibley should have been dealt with in the last Evergy rate case. We, at the time, OPC, had strenuously argued that it be dealt with in the last rate case. And the only reason we're here is because Evergy, in particular the testimony of Mr. Darren Ives, said it's not certain that we're going to shut down Sibley. So everything you heard from counsel from Evergy about how absolutely certain and planned out the company's retirement was, Evergy was telling you the exact opposite story in the last rate case. And if we had dealt with Evergy Sibley in the last rate case, if we had dealt with it when we should have, nothing that we discuss today would be relevant. But you can't fix the past. So we move on. We're here today. And there are 4 effective options in front of you that have been proposed for Sibley. You have the company, staff, MECG, and OPC. I'll start briefly with the company. Evergy is asking to earn a return on the Sibley investment. This is contrary to Missouri law. This commission, in the recent Empire financing case, recognized that earning a return on a plan that is not used and useful is contrary to Missouri law. That's all I'm going to say on that matter for now. I will address the rest in briefing. The simple answer is that it doesn't matter whether it was prudent or not. The company should not be earning a return on Sibley. Moving on to the OPC's position. Apologies. We are the only party who is questioning the prudence of shutting down Sibley. I don't intend to belabor this point for very long. Sibley is the largest generation that Evergy West had. It made up almost 25%, I believe almost more than 25% of the company's generation. The company has not made any real plans to replace Sibley after shutting it down. Instead, they're just buying all their energy off the market. The result is that their customers are now at risk because of market fluctuations. It doesn't matter whether it's a war in the Ukraine or a storm. The simple fact is they have put their customers at considerable risk of those fluctuations by not replacing the Sibley generation. That is the essential facet for why we argue it was imprudent to shut down Sibley. We also point out that, yes, it was retired 22 years early and that the company had sunk hundreds of millions of dollars into extending its life. And we figure those are other good reasons why it is imprudent. Like I said, I don't want to belabor this point too awfully much. However, I do want to briefly address one thing, and that's the concept of hindsight. The correct interpretation of whether or not something of hindsight is to ask this: what did the company know at the point in time when the decision was made? OPC has vehemently expressed our position on Sibley and the danger of shutting down Sibley early at every available opportunity. We explained it to the commission and to the company when the retirement was first announced. We explained it in the last rate case when there was the threat that it would be retired, and we have continued to explain it moving forward. The commission may disagree with our analysis that it was imprudence, but to suggest that this is hindsight is to create a truly impossible standard for the OPC to master. We have explained our concerns at every available opportunity before, during, and after the decision was made. That's all I want to say on hindsight. Let's move on. Let's assume that the commission determines that it was prudent to shut down Sibley. Fine. That really leaves two competing options, staff and MECG. Both parties are asking the commission to amortize the remaining net book value of the Sibley investment. There are a number of key differences that need to be considered, as you've already heard. And the most important one, in my opinion, is the starting point. What is the net book value? MECG, and the OPC supports this, wants to start where the commission left off in the last rate case. Even though the rate case was black boxed, the company's work papers and staff's filed true-up accounting schedules identically stated that the net book value was $300 million. That is what the company said. That is what staff said. That is what the rates were based off of. That is what customers ended up paying on. That is the correct starting point. It is what the commission ordered in the complaint case. So why the confusion? Well, during the complaint case, as you've already heard, Evergy presented testimony that tried to shift the accumulated depreciation reserves among its steam generating facilities. As a side note, the reason that Evergy is able to do this is because it has been booking its plants on an individual basis, but allowing its depreciation reserves to accumulate in a shared pool. The component in the stipulation presented by the parties that is meant to address this moving forward, so we can stop this problem in the future, which is another reason why the commission should approve that stipulation. But, as I've said, you can't fix the past. So, Evergy hired a depreciation expert to perform a theoretical reserve calculation to move depreciation reserve that had previously been applied to other generating facilities to Sibley. That cut the net plant balance of Sibley down to $145 million, roughly. I want to stress this. The commission never approved that calculation during the complaint case. The commission made no determination what the correct net book value of Sibley was at that time. Yet staff has decided to accept the company's numbers regardless. And that is where the big difference between the parties exists. On the one hand, you have MECG and OPC, who say to use what staff and the company agreed to in the last rate case when rates were set. And on the other hand, you have staff and the company who want to use an unapproved theoretical calculation from the complaint case. So what's the problem with using that theoretical calculation? Well, the answer comes from the fact that the company can't just add depreciation reserve. The depreciation reserve has to come from somewhere. So when you move depreciation reserve to Sibley, you take it away from the other generating plants. Why is that a problem? By decreasing the reserve for the other plants, you increase their net book value, which is what the company earns a return on. That means that you are driving up the company's return. This is the real key here. Evergy knows it can't earn a return on the Sibley investment under law, so it is trying to shift depreciation to allow the return it would have earned on Sibley, based on the rates in the last rate case, earned on other plants. It's a magic trick, a shell game. Instead of earning $150 million on Sibley, the company will earn $150 million worth of return on other plants. Sorry, they will earn a return on $150 million, not they will earn $150 million. I need to be clear there. Apologies. This is also, by the way, why staff's position is not a true Goldilocks position. Staff has implicitly allowed the company to increase its net plant reserve for the remaining steam generating assets by the roughly $150 million of shifted depreciation. That's what the fight is all about. So, by now I hope you can see why it's necessary to use the net book value of Sibley from the last rate case to calculate the unrecovered asset that needs to be recovered, as well as the return on component that should be used to offset it. The last thing I want to tell the commission is simply this. What should the commission do if it thinks securitization is the best course of action for Sibley? I want to make sure this is very clear. I'm not saying they should securitize it, not saying securitization is a good idea. However, this commission has, in my opinion, expressed interest in securitization. And I want to make it very clear, if that's the path the commission thinks the company should go down, what exactly would need to happen. If this commission thought that the company should pursue securitization, you need to go with the position offered by MECG. And the simple reason for that is, if you use the 145, roughly, number that the company and staff support, the asset that you will have at the end of the day, once you take off the O&M account and depreciation expense, won't be large enough to securitize. Again, I'm not saying you should securitize. I'm not saying it's a good idea. I'm telling you, if that's what the commission believes the best course of action is, you should take that into consideration. And on that point, I want to say two important things. First, if the commission were to agree with Mr. Meyer's position and allow Sibley to go into rates as an amortization, only for the company to then seek securitization, the OPC would be forced to bring a complaint case, just like in the last case, to address the fact that they would be effectively double recovering for Sibley. Similarly, if the commission were to go with MECG's position and the company were to seek securitization as a result, then the OPC would contest any transaction or legal fees that would come as a result of that securitization, because the company has fought this case all the way up to this point and would have wasted immense administrative resources if it then sought securitization after the fact. The OPC will offer two witnesses. The first will be Dr. Jeff Mark, who will be able to discuss the concerns related to the prudency of the retirement of Sibley. If the commission has any questions at all, I strongly encourage you to address them to Dr. Mark. Second, the OPC will present Mr. John Robinette, our depreciation expert, who will explain more of the problems that I just described regarding the theoretical reserve reallocation. With that, I will ask if there are any questions.
Thank you, Mr. Kleiser. Are there any commissioner questions? Hearing none, thank you, sir. We'll go ahead and get started with testimony. The first witness I have is Mr. Spanos.
Thank you, Judge. Yes. Jackie Whipple on behalf of the company, WHIPPLE, and we call Mr. Spanos Spanos.
Thank you. I'll go ahead and swear you in, sir. If you would please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And Ms. Whipple, go ahead.
Please state your name for the record.
John J. Spanos, S, P as in Paul, A-N-O-S.
By whom are you employed?
I'm employed by Gannett Fleming Valuation and Rate Consultants, LLC.
And what is your position there?
I am president.
Did you prepare direct, rebuttal, and surrebuttal testimony on behalf of Evergy Metro and Evergy West, which has been marked as Exhibits 71, 72, 73 in the Metro rate case, and the direct testimony has been marked as Exhibit 125 in the Evergy West rate case?
I have prepared those.
Do you have any corrections to your direct, rebuttal, or surrebuttal testimony?
I do not.
If I were to ask you those questions, would your answers be set forth as in Exhibits 71, 72, 73, and Exhibit 125?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes, they are.
Judge, I would now move to admit Exhibits 71, 72, and 73 in case number ER-2022-0129, as well as Exhibit 125 in case number ER-2022-0130.
Thank you, and I will call it all in one question. Are there any objections to the admission of the stated testimony by Mr. Spanos? And that would be Exhibit 71, direct, Exhibit 72, rebuttal, Exhibit 73, surrebuttal. Those are all in file number ending 0129, and Exhibit 125 in file number ending in 0130. Again, my question is, are there any objections? Hearing none, they're so admitted.
Thank you, Judge. Tender the witness for cross.
Thank you. My handy-dandy new cross-examination list. Thank you, sir. Charge point. Any questions from Charge Point? Any questions from Google? No, Your Honor. Any questions from Nucor? Any questions from Velvet Tech?
No, Your Honor.
Any questions from St. Joseph? Any questions from Dogwood? Any questions from Sierra Club? Any questions from New Missouri?
No, Your Honor.
Any questions from staff?
No, thank you.
Any questions from MIEC? Any questions from MECG?
No, thank you, Your Honor.
Mr. Kleiser, Office of Public Counsel. No, Your Honor. Thank you. Mr. Spanos, the bench does have a couple questions. Before I get to those, I'll ask if there are any commissioner questions for witness Spanos. And if you're on the phone, it is *6 to unmute. Hearing no questions, I'll go ahead. I do have a couple. How many depreciation studies have you performed for Evergy West?
I conducted in 2010 for the predecessor companies at the time. Then I conducted another study through 2014, which was in 2016. And then I've conducted these studies in 2021 that would have reflected all full comprehensive depreciation studies.
And I just want to make sure I caught that. You did perform the 2 depreciation studies prior to the last rate case. That would be an ER-2016-0156 and ER-2010-0356.
Yes, I did. And I think it's important to note, which is creating quite a bit of confusion here, is during those times we transitioned from the whole life method to the remaining life method and lifespanning of generating facilities. And when you do those components, that is when you focus on what the net book value is of assets. And prior to those times in Missouri, those components, whole life and no lifespanning, was the practice. So you'd never maintained the accumulated depreciation at the location level or in the detail that is calculated for the approved rates that have been in place for the last 2 rate cases.
Did Evergy obtain commission authority to change that from whole life?
Yes, both of those components were part of those rate cases and approved as part of those rate cases. And in those cases, we have presented location-specific amounts that were part of the development of the rate at the account level. So those are some key components that are part of the studies and how that's been developed and the rates that were approved during those time periods.
One of those studies is what said Sibley had an extra 40 years of life. Is that correct?
It was not an extra 40 years of life. It was, at the time when you were conducting studies in the 14 case, we had incorporated some additional investment that was required to be done in order for coal facilities to meet the environmental regulations. So we extended the life, which is consistent with what the practices were to 2040 at that time. That was a standard practice. But what we have seen happen due to regulations, particularly environmental regulations in recent years, is many coal facilities are needing to be retired much sooner in time, and that is what's been a reflection comparable to Sibley. Many of those assets are only lasting 45 to 50 years overall, regardless of the assets they have in place. And that's consistent when, in the case of Sibley, they made it 50 to 60 years. So they even exceeded, all of those units exceeded the general lifespans of coal facilities that we've seen in recent years.
I'm looking for a list of the causes. In my mind, and correct me here, in my mind, how this is playing out is Sibley needed to make some upgrades to burn the low sulfur and low ash. Those upgrades cause the extension of the depreciable life, perhaps due to the upgrades being new, so maybe it was looking more at the depreciable life of the upgrades themselves. I'm not an accountant, very obviously. But my question is, A, we switched from whole life. That had an effect. But I'm not hearing that that was the whole effect. So public pressure, I think, in the last few years, certainly. But is there a second one in between in the last 20 years or the last, 8 years or so, where there's another factor? You had mentioned the cost of coal and I think switching locations to get coal from Wyoming.
There are a considerable amount of costs that are required to operate a coal facility. And when you have those costs and with the environmental regulations in order to operate the assets, there is a cost-benefit analysis that's necessary to assess whether, even after the investment has been incurred, in order for it to meet a life expectancy, there still becomes cost as to whether that's still a viable solution to generate. And you have renewables in place now that are helping drive the recovery pattern or utilization of generation for ratepayers. So when you incorporate all of those factors, there are decisions that are needed to be made as to what is the most appropriate recovery pattern for each generating facility. And those things have changed. The cost that would be required to keep Sibley moving up through and be efficient were factors that came into play.
Do you know if your testimony from the complaint case, the AAO complaint case, which was, for the record, EC-2019-0200, let me get back to my question, was your testimony from that case included in this case? Attached as an addendum or something onto your current testimony?
It was not included in my testimony that I'm aware of. I did incorporate the same methodologies and how we develop the net book value of each of those units based on the information that was conducted in that case and how I conducted my study this time, and as well as how the study was performed and the rates approved back in the 2016 case. So all of those things are consistent. I think it was a little bit misconstrued in some of the opening discussions in that the development process was not just a random theoretical calculation. It has been built up for many years as to how you do the process with these methodologies. So although the testimony isn't specifically in line with or attached to my exhibits in this case, it's all in line with the same discussion and methodologies.
Thank you. That is all the questions I have. Let us return. That takes us to recross-examination. We'll go in the same order. I'll go through some of the interveners that we've noted have been excused more quickly. Charge Point, any questions on recross? Google? Nucor? Velvet Tech?
No, Your Honor.
St. Joseph? Dogwood? Sierra Club? Renew Missouri?
No, Your Honor.
Staff? No, thank you. MIEC, Missouri Industrial Energy Consumers, that's MIEC, and MECG, Midwest Energy Consumers Group.
No, thank you, Your Honor.
Thanks. Mr. Gleiser, thank you. Mr. Spanos? Oh, not yet. I even made a cheat sheet for myself so I wouldn't forget. The court reporter will have fun transcribing that. Thank you. Redirect.
Thank you, yes. Mr. Spanos, in response to questions from the bench, you stated that some comments in opening statements misconstrued your testimony or your depreciation studies. Would you please elaborate on that?
I object. It's outside the scope of your question. His comment is not directly responsive to the question that you posed.
Your Honor, MECG would join OPC's objection. It's a case where the witness was cut off. He was voluntarily offering this. He already testified what he was going to testify about that.
Yeah, I'm sorry, Ms. Whipple. I apologize, Ms. Whipple. We have been limiting our redirect to just questions raised from the bench.
Understood. Mr. Spanos, in response to questions from the bench, you did discuss past depreciation studies that you have conducted on behalf of the company and which were used to develop rates. Is that correct?
Yes, we did, as we discussed, the last few cases, which were based on remaining life and the lifespan for generation, we did create net book values and the rates for each of those particular locations were developed, which showed what the net book value was. In the case of Sibley, it was clear that the net book value was considerably less than what was presented by others in their opening statement, and that is proof that you have a 50 to 60 year asset that has at the time had 400 plus billion investment, and to come up with a net book value that would have only recovered 25% of that when it's expected to live 60 years is why the presentation of it just being a theoretical calculation was not accurate, and that was why I said that was inconsistent. And the rates that were developed from those studies and what were approved going forward in methodology support the fact that the net book value was much less for Sibley than what was stated.
Do any of these past depreciation studies show that the net book value of Sibley is $300 million?
Not the depreciation studies, it's clear in each of them that the net book value back in the study done in 2014 was much less than 300 million. And obviously, as you move forward, the same types of calculations are shown in the work that had been done that shows that that value is much less, and why we came up with the 145, because it appropriately recovers the information related to plant and service each year from 1960 all the way back, or all the way forward to the time of retirement.
Do you recall discussing with the judge your 2014 depreciation study, which was in the 2016 rate case, ER-2016-0156?
I do remember having that discussion and explaining the methodologies that were used there, which are consistent with what's used here.
I've handed out your rebuttal testimony from the 2016 rate case. Is that correct?
Yes.
And is it correct that this is just your rebuttal testimony, because we're saving some trees here and we didn't print out all of the hundreds of pages of schedules that would have been attached to that?
It is correct. This is only the rebuttal testimony. It's not the actual depreciation study exhibits, which were filed at that time.
Does this rebuttal testimony reflect the methodology that was utilized for the 2014 depreciation study in any way?
It describes the fact that the lifespan approach and remaining life methodology were determined, and that you calculate the individual by account rates and then the composite rate by account, which is the overall rate that is being utilized. So it does have the development of the account rate based on all the individual rates of each generating location.
Can you please turn to page 3 of your rebuttal testimony?
Your Honor, I'm going to object. This document is hearsay at this point because it is, well, it was prepared in a prior case and it has not been subject to cross-examination. And because it's attempting to be brought in through direct or redirect, it will not be subject to cross-examination. He's attempting to effectively offer new testimony from a prior case without any cross. I would also point out that that last case was settled, so this was never offered to the commission in that case either.
Thank you, Mr. Kleiser.
Judge, I think this is fairly in response to bench questions.
What was your question? You started on, turn to page 3
Yes.
and then,
Turn to page 3, and I'm trying to show that there's Q&A that starts at the bottom of page 3 and into page 4 that describes how the whole life methodology shifted. And then, of course, this was as of 2016 in the 2016 rate case. This was part of the discussion that you had with Mr. Spanos.
yes, it is. I'm going to allow the question, and also I would like to prepare the parties in advance. The commission is interested in getting Mr. Spanos's direct testimony from the complaint case. I don't know how that is going to proceed quite yet. I just want to put that thought in everyone's heads. Maybe we can come up with a solution over the break. I don't know.
Yeah, to the extent that the commission is going to allow in testimony from a prior case that hasn't been subject to cross, or the testimony from the complaint case, which I imagine was subject to cross in this case, would it be possible to retain Mr. Spanos in the event that other parties had cross directly related to either of those documents? That would seem as a due process.
That certainly seems reasonable, Mr. Spanos. I do not know your travel schedule, though, and I do not want to impose that. I could offer a WebEx. That does seem appropriate, though, if we're going to introduce, I think, the two previous testimonies, that mine and yours. I'm seeing nods of assent. Let's go ahead with Ms. Whipple's question.
Can you, I'm orienting you now to the page 3 and 4 portion of your testimony. Can you point out to us where you describe this methodology that you were discussing with Judge Hatcher?
Well, the discussion in the rates and how things are moved forward are at the bottom of page 3, where we talk about how a depreciation study is done and how it's consistent with the rates that were approved based on the staff report as well as my depreciation study. And then as we move on to page 4, we talk about the concept of including that in '05 we did not include the lifespan approach and we utilized whole life. Now we've moved on to remaining life, and the purpose of remaining life is to make sure you ensure full recovery of your investment, no more, no less, and you monitor that on a unit basis, and that's how things are developed. So this is the process and discussion that is part of the question and answer on page 3 and 4.
So the calculations of depreciation reserves by and location developed in 2018 and in your depreciation study in this case were a continuation of the methodologies utilized in ER-2016-0156. Is that correct?
That is correct, because that's when the lifespan and remaining life components were built in. And as you can see in those calculations and the basis for the rates that were approved utilized a calculation by unit process. It also then moved it forward into the 2018 work and then in this 2021 case, which is consistent with that process. The only difference during that time is from the 14 case to the 18 case or work that was done in the accounting order, you had to revisit the actual calculations on that unit basis to understand the whole life method and the lack of a lifespan approach that was not in place up until those times. So you had to revisit that and assign the appropriate reserve recoveries for each of those based on how long they have lived at that point in time. So that's my point in understanding the fact that you had a 50 to 60 year asset that's now lived 50 or 60 years, you should have recovery that is pretty close to the original cost. And that's why these calculations have shown that for the last 8 years.
Judge, at this time, I would like to admit what would be Exhibit 88 in the Metro rate case, case number ending in -0129, and what would be Exhibit 130 in the West rate case ending case number -0130.
Say that again. I'm
Like
not
to-
following. Are we introducing this?
Yes.
Twice.
Mr. Spanos' rebuttal testimony from the 2016 rate case, which would be Exhibit 88 in the Metro case and Exhibit 130 in the West case.
Okay, to restate that for everyone, the one exhibit rebuttal testimony, which we have been discussing with Mr. Spanos, will serve as two exhibit numbers. Exhibit 88 in file 0129 and Exhibit 130 in file 0130, coincidentally. Are there any objections to the admission of the rebuttal testimony?
Yes, so I will once again renew my objection, although I'm fairly certain how the commission is going to rule on it. Just to reiterate for the record, this is hearsay that we have not, as OPC, had an opportunity to cross-examine, and therefore it would be inappropriate to include it. I would also point out that I don't see the reason for including the Metro portion, even if it's the same document, because the Sibley issue is exclusive to West, and is also the only version that's been presented. So as far as including it as two exhibits, I don't see why that's necessary, and would ask for just the West if the commission overrules the hearsay objection.
As far as having it just in the West case as Exhibit 130, that's fine.
Let's do that. Are there any other objections?
Your Honor, I guess I'm not necessarily going to object, but I would ask that I be permitted to ask Mr. Spanos a question or two about that document before he leaves the stand today.
Yes, this is a point of interest to the commission. So yes, more questions would be appropriate. Let me think through that for a second. Because OPC had asked for a little time, I think was the essence of their question, to then come back. I am granting that.
I just have one question.
Go ahead and we'll see where we're at afterwards.
Judge, this is Jim Fisher. Mr. Spanos is available tomorrow, and if council would like to look at that overnight and do some cross, he could do that while he's here, or whatever.
It would be more effective if it could be done today, but I know that that's asking a lot for people, but I do have a flight tomorrow morning. I can try to change it, but that was my concern.
Not to add to this, I just need a little bit of time. I'm not saying that I have questions. I would offer that MEC, since they have a question now, be allowed to ask it, and that Mr. Spanos potentially be brought up at the end of witnesses today, and hopefully sometime we'll break for lunch and that'll give me a chance to read it.
I'm going to go with that solution. Mr. Opitz, go ahead with your question, and I will try and figure out who gets to ask after that.
Thank you. Mr. Spanos, were rates that you calculated in this Exhibit 130, in that case, adopted for rate-making purposes?
The methodologies and concepts were approved. There was,
Mr. Spanos, that wasn't my question. My question was, were the rates you calculated in that case adopted for rate-making purposes?
and the reason why I answered the question in the fashion is because that was the transition time period. So staff's position and my position were the same, but they had to revise the rates from that study to deal with terminal net salvage. That was the difference between those. All the concepts were the same, and that was the point that I was trying to make.
Mr. Spanos, the rates you calculated in that case, in this testimony, were not adopted for rate making, correct?
Not every single count, most.
The rates in this testimony were not adopted for rate making, correct?
Judge, asked and answered at this point multiple times.
I'll let it go, Judge. Thank
Okay.
you.
Okay. I asked Ms. Whipple a question. Counsel, I don't want to get into strategy. Is there a plan to offer Mr. Spanos's direct from 0200 by Evergy, or should I be prepared to look into how to offer that as a commission exhibit?
Just one moment, please.
Judge, this is Carl Zobrist. We don't have an objection to that. We could make it a late filed exhibit. My understanding is in this case, much of the record, including discovery from the MECG, OPC, AAO petition was included in this case. So we have no objection.
Okay. Yeah, the purpose that the commission seeks the information is tracing back the calculations. Are there We'll get to that exhibit a little later. Thank you for the heads up. We have seemingly revisited cross-examination. Let's go ahead and we will go back through the routine and hit all of the available parties for cross-examination. No? Give Mr. Kleiser.
Theoretically, I think you would only need to do all the recross after MECG, unless another party requests it.
I'd just as soon open it up. Does anyone have a question for Mr. Spanos?
Staff does not have any now, but just to join in with Mr. Kleiser's thought that we would, after doing both the direct, it sounds like, in the 200 case, and then this new exhibit just potentially may have something, so I don't want to foreclose anything.
I will make sure that the questioning of Mr. Spanos later today is open to all parties. Any other questions for Mr. Spanos? Ms. Whipple, redirect again?
I would reserve, of course, for after the second cross session, but at this time, no further questions.
Okay. I'm going to go ahead and excuse Mr. Spanos for this morning. Before you step down, sir, I would like to point out it is a couple minutes after 10. Let's take a break until 10:15. Then we will come back. On my list, the next two are going to be Evergy witnesses Kennedy and Ives. We're off the record. That's my favorite part of the job. Let's go back on the record. I have on my schedule 8 more witnesses to get through today. For Evergy, go ahead.
Judge, could I interrupt for a moment? You mentioned that the commission was interested in seeing Mr. Spanos' direct testimony in the complaint case. And we're fine with that. He does not have direct. He has rebuttal testimony in that case.
And I just looked at my note and I misread your testimony. So yes, his testimony from 0200 is what the commission is interested in.
Testimony, okay. I think it's rebuttal, so we'll double check that.
We will have time to circle back around. Evergy, go ahead and call your next witness.
Thank you, Judge. Evergy calls Larry Kennedy to the stand.
Mr. Kennedy, I'll remind you, as I have all of our witnesses, for the benefit of our future court reporter, please talk into the microphone and speak slowly. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Please have a seat. Your witness.
Thank you, Judge. Please state your name and state it slowly.
Larry Edwin Kennedy, that's Kennedy.
And by whom are you employed?
Concentric Energy Advisors.
And what is your position there?
I am a senior vice president.
Mr. Kennedy, did you prepare in this case direct testimony, which has been marked Exhibit 114, and rebuttal testimony, which has been marked Exhibit 129?
I did.
Do you have any corrections to those exhibits?
I do not.
And if I were to ask you the questions contained in Exhibit 114 and Exhibit 129, would your answers be as set forth in those exhibits?
They would.
And was your testimony given under oath?
It was.
Judge, I move the admission of Exhibit 114, Mr. Kennedy's direct testimony, and Exhibit 129, Mr. Kennedy's rebuttal testimony.
Thank you, and I'll ask in one combined question, are there any objections to the admission of Exhibit 114 or 129? Hearing none, they are so admitted. Go ahead.
Thank you, Judge, and I tender Mr. Kennedy for cross-examination.
Thank you. Let's get our order of cross. Again, I will go through some of the excused parties just to inquire if they're here. Charge Point, Google, Nucor,
No questions, Your Honor.
Velvet Tech,
No questions, Your Honor.
St. Joseph, City of St. Joseph, Dogwood, Sierra Club, Renew Missouri,
No questions, Your Honor.
and staff.
Briefly, Your Honor. Mr. Kennedy,
This is Nicole Mers.
I apologize.
No, I forgot this morning too. My apologies. Go ahead.
Mr. Kennedy, in your direct testimony on page 18, you reference a NARUC depreciation manual to support your contention that return of and on is proper. Do you recall that testimony?
I do.
Do you recall what year that manual was written?
1960-something.
Okay. And do you recall on the following pages in your direct referencing a text by James Bonbright to support the contention that commissions widely support return of and on the plant?
That publication, the initial publication, I believe, was written in 1961.
Okay. And then you also discuss in your direct two Public Utility Commission decisions on retirement. I believe that's on page 34. Do you recall that?
I do.
In the Alabama decision you reference, isn't it true that the regulatory assets were established prior to the retirement of the plants?
I do believe that is the case.
And you also discuss a Colorado decision. And do you recall when that case was decided?
I think the decision was in 2009.
Okay, thank you very much. I have nothing further.
Thank you, Ms. Mers. MIEC. Mr. Opitz for MECG.
No, thank you, Judge.
And Mr. Kleiser for OPC.
No questions. Thank you, Your Honor.
Thank you. The bench has no questions. That would take us to redirect.
Just briefly, Judge. Mr. Kennedy, Ms. Mers, on behalf of staff, asked you about the decisions and the treatises that you cited with regarding return on and return of issues. Do you recall that, sir?
I do.
Okay. And since the 1960s, what has been the recent trend in these kinds of cases where return on and return of have been discussed and decided by public utility commissions in the United States?
So since the 1960s, there was a period of time where there was a variety of decisions. Most, I would say, have allowed the return of investment, and most, if not, or many, if not most, have allowed the return of investment in one form or another, either through being included in rate base of the net book value or through regulatory assets that were allowed to have a return on associated with them. Through the early 2000s, I would say we saw a mix of decisions, and I would suggest that from approximately the mid to 20-teens, 2014, 15 through now, we're seeing a predominance of decisions that allow both a return of and on the retirements of early retirements of assets. And again, that return may be in the form of the net book value going back into rate base, or it may be the net book value going into regulatory assets of some form and having a return on and of that investment through the regulatory asset process.
For a period of years.
For a period of years, particularly when it goes in through the regulatory asset, there's usually a time period associated with that recovery amortization of the reg asset.
Thank you, Judge. That's all I have.
Thank you, Mr. Kennedy. You are excused.
Thank you.
Mr. Ives, welcome back. I'll remind you, as I tried to, please speak slowly for our future court reporter and into the microphone. Please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Your witness.
Please state your name for the record.
My name is Darren Ives, I-V-E-S.
Mr. Ives, where do you work and what is your position there?
I work for Evergy, and I am the Vice President of Regulatory Affairs.
Mr. Ives, did you cause to be filed in this case? And when I say this case, I mean the Evergy Metro case, 0129, direct testimony that has been marked as Exhibit 39, rebuttal testimony, the confidential version, which has been marked as Exhibit 40, public version of your rebuttal testimony, which has been marked as Exhibit 41, surrebuttal testimony, which has been marked as Exhibit 42, and in the Evergy direct testimony that has been marked as Exhibit 113. Did you cause those to be filed?
I did.
Do you have any corrections to those testimonies?
None that I'm aware of.
Are the answers contained in those testimonies that I listed true and correct to the best of your knowledge and understanding and belief?
Yes, they are.
Your Honor, I'd like to move for admission of the Ives direct rebuttal and surrebuttal testimony in the Missouri Metro case and the Ives direct testimony in Missouri West case.
Thank you. And speaking was Roger Steiner, counsel for Evergy. Counsel, you have heard the question. I'm going to combine them as I usually do. Are there any objections to the admission of the aforementioned exhibits? I'll repeat the numbers: 39, 40, 41, 42, or 113. Any objections?
Judge, I'm sorry, can I ask a question?
Yeah.
I believe Mr. Steiner just referred to my rebuttal and rebuttal as applicable to Metro. Both of them covered both companies, both 0129 and 0130.
Thank you, Mr. Ives. That was my mistake, yes. Those testimonies do cover both cases.
Understood. We will have the record reflect that the testimony offered in 0129, in fact, does address 0130 as well. Any objections?
Not an objection, just point of clarification. If I remember correctly from your order, there were two sets of exhibit numbers for Metro and West. So are they two different exhibits? I'm just trying to figure out how that works, sorry.
With a lot of the filings, I'm sorry if I cut you off. With a lot of the filings, we have had double numbers indicating that they're being filed in both cases. Let me back up. The commission wants to keep the two rate cases separate for whatever happens after the commission's decision, for the ease of keeping the record together. For our purposes, I'm not too worried about identifying the number because it's going to be in our briefs and our order that all of us in the room are writing as to how we refer to that exhibit.
Okay,
As
because
long as
you gave 0 through 100 for like EMM and 100 through 100 for
Oh,
West.
I see.
So
That's-
the
We
rebuttal-
actually filed two testimonies in direct, one for Metro, one for West, but then the rebuttal and surrebuttal, we filed one testimony, but it applies to both cases.
So it would be like there'd be a number for West and a separate evidentiary number being offered for Metro. The exhibit would have two different exhibit numbers on it, based on the commission's order.
We don't have it set up that way, we just have we have separate, when we filed two separate testimonies, but when we filed one testimony, we just used the Metro numbering system.
I understand the confusion. To me, it seems more theoretical than practical, and therefore I'm going to let it go. I also made some mistakes in that order, not specifying that confidential testimony would have the same number as the public, but just with the C designation. So the presiding officer certainly takes some responsibility for that. Noted and will be fixed in the future, sir. Thank you. Let me get back to my question. Any objections to the admission of the various testimonies of Mr. Ives that may or may not apply to both cases? Hearing none, they're so omitted. Thank you, sir. Evergy.
Thank you, Your Honor. I tender this witness for cross-examination.
Thank you, and we will go again quickly through those excused. Charge Point, Google. No questions, Your Honor. Nucor.
No questions, Judge.
Velvet Tech.
No questions, Your Honor.
City of St. Joseph, Dogwood, Sierra Club, Renew Missouri.
No questions, Your Honor.
Staff Counsel,
No questions, Your Honor.
MIEC. MECG, Mr. Opitz.
No, thank you, Your Honor.
Office of Public Counsel, OPC.
No, thank you, Your Honor.
The bench does have a few questions. Before I get to mine, I'd like to ask if any of the commissioners have any questions for Mr. Ives. Again, it is *6 to unmute.
No questions, Judge.
Thank you, Chairman. And for the record, all 5 of our commissioners are on the WebEx. Mr. Ives, OPC's opening statement caught my attention a little bit, and I would like to follow up with an opportunity. Why didn't Evergy replace Sibley?
Why didn't we replace it? What caught my attention too for another reason, but in regards to your question, why didn't we replace Sibley? There's a lot of factors that go into integrated resource planning. Certainly, Ms. Messamore will be here next week, and she's our expert in that area, so able to elaborate. But when we look at the analysis, a couple things we know, right? We're probably not replacing it with a nuclear facility. We're probably not replacing it with in today's environment, with a coal facility. Natural gas is difficult on a lot of fronts. Some because of the volatility in natural gas pricing, but mostly in our service territory because of the availability of natural gas on a firm basis and the availability to get it to facilities. So at this time, we have utilized our participation in SPP, and what we did do at the time that we retired Sibley is we did an RFP to enter into a capacity agreement to make sure that West could sufficiently meet its capacity obligations on a standalone utility basis to SPP. We ended up entering that agreement with Evergy Metro after conclusion and evaluation of the RFP, but we did put a 5-year term capacity arrangement in effect to take care of that. And then the energy is, at this stage, being procured in the SPP market at the day ahead or real-time price under the market.
And again, this is Judge Hatcher. I may be misremembering. Did Evergy Missouri Metro have excess capacity? Or I might have that backwards. Missouri West?
Metro has historically had some capacity in excess of the SPP requirements. That's why they were able to bid into the RFP for West. West was short at the time, which is why they needed to go out and fill a capacity contract.
In my mind, the question that is raised is maybe more of a philosophical one, because after hearing OPC's opening statement, my first thought was, if you're not producing electricity, this may be a new entity in Missouri, one that is just distributing. But it sounds like this was one of many generation plants, and I haven't heard you comment on future plans, and I don't want to ask about those plans.
If this would help, I would tell you that we have filed integrated resource plans. We do on a triennial basis, and we do annual updates, and those are overseen and prepared by Ms. Messamore. So if the judge or the commission has questions on future plans, she'd be available to address those next week.
Thank you. I appreciate that. Kind of the second the second area that really caught my ear was the description of Evergy discovering that Sibley had some mechanical issues, I guess, and needed the $2 million upgrade. And what looks like a beneficial, or depending on your point of view, a terrible coincidence that as the rate case is going on and decided, Evergy then later makes a decision to go ahead and close Sibley permanently. I do understand the background, and for the record, my understanding is that conversation had been going on and notice to the commission had already occurred in years prior. But that timing, I think the question is that a coincidence or purposeful? So I would like to hear from Evergy, kind of what your view of that difference. And I understand that there's going to be a lot of levels between the person at Sibley on boots on the ground and getting a message up the flagpole. So if you could give me your thoughts on that.
Yeah, so I really appreciate that question because there's some pretty interesting testimony in this docket from both myself and other parties on this topic, and it's worth clarifying. There's a lot of questions on that timing. The first question on the timing was, before we ever filed a case, as you alluded to, there were a number of communications about the expected planned retirement of the Sibley units. And it was out there that we expected them to be retired at the end of 2018. We filed a case based upon the primary driver of that case had nothing to do with Sibley. It was about bringing in our customer billing system that we had upgraded, that is a short-lived IT system that it's important to time cases close to in-service or something like that because they recover over fairly short windows. So to the extent you don't time that well, you cannot recover as a company significant amounts of an IT system like that. So with that said, we knew that the likely true up in that case to put that computer system in was going to be June 30 of 2018, which was before our expected retirement of Sibley. The historical treatment in the state of Missouri has been to have a hard cutoff at true up for the determination of rate base and cost. My position in that case, which is articulated in a lot of testimony, was Sibley, if it retired at the end of December, would be past the time of effective date of rates and 6 months past the time of the true-up in that case, and was not ripe to be addressed in that rate case. I filed a lot of testimony on that. The parties disagreed. So we had some discussion, but ultimately there was a settlement agreement that moved forward with that treatment in the revenue requirement, not addressing Sibley at that time. Then we had the unit trip in the turbine damage, happened on September 5th, in the midst of the case. Not uncommon to have some forced outages at units. This one happened to be at Sibley Unit 3, which was near the term of its expected retirement. we did the work that would have been expected to be done. We made an initial assessment. We decided to open up the turbine and see what potential damage happened and what would be remedy. And as you mentioned, we ultimately determined that it was going to be about $2.2 million and a period of time to invest and do that work. We should just address the email that is part of this discussion while we're at it. Dr. Mark talks about an email that was circulated by the Vice President of Generation on the 2nd of October. In that email, he said, we've made our assessment of the options to proceed, and we intend to move forward and work towards retirement of Sibley 3 and make contacts. What happened from there, which is not in Dr. Mark's testimony, but it was in the complaint case, is there was a communication back from our chief operating officer in response to that email on the 3rd that says, appreciate the team's work and recommendation, but essentially said you don't have the final say on this decision. You need to bring that in front of the broader officer team and executives, and ultimately we will probably have to inform and discuss with our board of directors before we make a final retirement decision. And then there's further email strings that ultimately take us to the final decision after all those steps were taken to retire Sibley, and that decision was made on November 13th. So still within the time frame that the commission was working through its order, maybe had issued its order by that point because rates went effective on December 6th, but before rates took effect. Doesn't change the fact that the retirement, for whatever purpose, happened after the true-up period in that case. And I think the last thing I would say is it's fair to look at the opposite side. Had we been planning to put an investment in place at December 31st, the commission and the parties would have said, that's past the true-up period and you don't get to put an investment in these rates. Had we closed that investment early in September or October or November, the parties would have continued to say that you don't get to put that investment in rates in this case because the true-up was June. That's how we handled the retirement from Evergy's perspective. It was not a game. It was following what we knew the historical treatment had been for true-ups in rate cases and what the treatment would have been if the inverse had been true and we had been putting an investment in and not taking one out. That was our thought. That was what the testimony that I gave in that case, the testimony that I gave in the complaint case articulated.
I'm going to rephrase and ask if I'm rephrasing correctly. Based on Evergy's experience with a hard true-up date, the expense of building new generation would be borne solely by the shareholders until the new plant is A, used and useful, and B, Evergy files their next rate case. So let's stop there. Is that a good summary?
Yes, generally. I mean, a couple things that could be said. Probably fair to say we could we could file for an accounting authority order. The one thing that is true to your statement is we would not have been allowed to include it in a rate case that had a true-up of June 30th, 2018, based on any historical experience I've had with these parties or the commission.
Can you expand on how Evergy took its ratepayers into consideration in that calculation of ending generation and replacing it, at least temporarily, with purchased power?
Yeah, I mean, I think we took the ratepayers into consideration as we would when we have regulatory lag, timing differences on the other side of the equation, that there are only so many things that are allowed to be done within the true-up of a case historically in this jurisdiction. I should say same holds true for the other jurisdiction I work in Kansas. I'm not just saying Missouri, I'm saying it because we're here. We have a historical construct in Kansas as well. And that there are avenues for parties, should we come out of a rate case and we ultimately have positive regulatory lag, which is what this Sibley situation could have occurred in, where there's a process in front of this commission to file a complaint and demonstrate over earnings. Just like parties would say, if we don't get an investment in by the true-up, there's a process for us to do that, which often is said, you control the timing of your rate cases, Evergy, you can file a case and bring it in.
And that's your responsibility to the shareholders.
It's my I have a responsibility to shareholders and ratepayers. There's no doubt about that. But I also have a responsibility to follow the process consistently that's laid out in front of me in the state of Missouri.
Thank you. That's all the questions that I have. That will take us to recross-examination. And let's go to our handy list. Again, I'll go fast over the parties that have been excused, just in case they have walked into the room. Charge Point. Google.
No questions, Your Honor.
Nucor.
No questions, Judge.
Velvet Tech.
No questions, Your Honor.
City of St. Joseph. Dogwood. Sierra Club. Renew Missouri.
No questions, Your Honor.
Staff Counsel. MIEC. Next is Mr. Opitz with MECG.
No, thank you, Judge.
And Mr. Kleiser, OPC.
Yes, Your Honor.
Go ahead.
Good afternoon, Mr. Ives. Oh, morning still, pardon me. Good
Good
morning,
morning.
Mr. Ives.
Feels like afternoon.
It does. Just, I want to make sure that the record is very clear to start with. The Sibley Generating Facility had stopped functioning by the end of October.
Well, technically, the Sibley unit did not generate electricity after it tripped on the 5th of September. But as I mentioned, we made the official determination the 13th of November to retire it after speaking with management and the board.
But so we would agree that the plant had ceased generating electricity long before the decision to formally retire it had occurred.
When we had the forced outage, it was not able to generate any longer.
And now I know you mentioned this, but you would agree with me that Evergy has the ability to determine when it comes in for a rate case.
We do.
And you also have the ability to determine or request what the true-up period of a rate case should be, correct?
Within a pretty limited bound based on the schedule, right? I mean, we all as parties, once a case is filed, know roughly what that time frame is for true-up. It may move within a month of each other, once a case is filed.
But if Evergy knew that it was going to have a significant investment coming in shortly after what it expected to be the end of a rate case, it could, in theory, ask for an isolated adjustment to address that, could it not?
I've tried that before. I've never been successful.
And you mentioned a process by which the company could, or other parties could address the issue related similar to Sibley, right?
Can you restate that? I missed.
Certainly.
Missed it.
You mentioned a process by which other parties could address a situation similar to Sibley regarding filing a complaint case. Do you recall that?
I do recall that.
And that's what happened in this case, correct?
It is from an AAO standpoint. I think the appropriate form would have been a over-earnings complaint. But that was not the commission's decision.
No further questions. Thank you.
And redirect Evergy.
Thank you, Judge. Just briefly, Mr. Ives, you recall discussing an RFP for excess capacity that Metro issued? Excuse me, that West issued?
Yeah, thanks. West issued that, and I think I mentioned to the judge that ultimately Metro ended up being the supplier.
And why were they chosen? Do you recall?
They were the best price opportunity for West, primarily because they have kind of integrated transmission service that other suppliers for capacity wouldn't have.
And I think there was discussion with Judge about West's other generation. West has other generation besides Sibley, correct?
It does. It does. We have an ownership interest in Jeffrey units. We have some natural gas units. We have ownership interest in the Iatan station that not only Metro, but some other parties have interest in as well.
Do you recall a discussion with the judge where he said, where did you take the ratepayers into consideration?
I do recall that.
Does the IRP that the company conducted show that closing Sibley was a benefit for ratepayers?
Absolutely. I think Ms. Messa-Moore has that in testimony, but it was in the range of a couple $100 million on a net present value revenue requirement basis to retire Sibley under our IRP scenarios.
You also were talking to Mr. Kleiser about the forced outage. Do you recall that?
I do.
Could you tell us, did the company evaluate repair of Sibley after that?
We did. We evaluated repair. We evaluated early retirement. It's probably the last piece of information that I didn't put in my response to Judge Hatcher, but it's related to this, right? I mean, when you think about repair, one of the reasons you do that and you take that to the senior executive team and ultimately discussion with the board is because you want to make sure that you've considered anything that's going on in the broader SPP market or any concerns at other generating facilities that might make it the option that you should extend the life past that expected retirement date to have appropriate availability and reliability for customers. That was the reason why we would consider repair, and that ultimately was determined not to be the path, but it was a consideration.
So the bigger picture of spending money to repair the plant was evaluated before the decision was made to shut it down. Is that correct?
Yes, I mean there was a month plus of considerations that were given to scenarios around Sibley before we coalesced on the earlier requirement.
And those scenarios being market conditions, upcoming other conditions in the market?
Yeah, as I mentioned, it's, what's going on in the broader SPP market that could impact reliability, what's going on in the remainder of our fleet, did we have any long-term extended outages that would impact customer reliability that we could mitigate by spending the $2.21 million and operating Sibley, possibly longer than the December 31st expected retirement date.
Okay, thank you. You had a discussion with the judge about emails that were mentioned in Mr. Mark's testimony, that when emails were discussing the Sibley plant. Do you recall that?
I do. I was mentioning, Judge Hatcher, that Dr. Mark referenced some October 2nd emails. I think he typed the text in his testimony, actually, from those emails, but did not mention the follow-up emails that occurred on the topic after October 2nd.
Your Honor, may I approach? Judge, in the procedural order in this case, there is a provision on page 6 that data requests in the EC 2019-0200 case could be treated as being made in these cases. And so I'd like to use that provision to talk to Ms. Ives about a DR in that case, which has the full set of emails that Mr. Ives was talking about. And then I'd like to get this admitted into the record once he identifies it.
Are there any objections?
I have no objection to using the DR per the commission's order. If Mr. Ives lays the foundation, yeah.
Okay, go ahead.
Mr. Ives, I handed you a document. Do you agree that this is the email chain that is referenced in your discussion with the judge regarding an October 2nd email and emails following that?
Yeah, it's actually a pretty extensive string of emails that were evaluated around the turbine trip. It starts back in September, where we start to get some preliminary analysis back from the operations team on what they've identified as they've started to unpack the cause of the forced outage in early September. Goes through the October 2nd emails that Dr. Mark refers to in his testimony, and then progresses forward from there in terms of the response to that email that was provided on October 3rd by Mr. Kevin Bryant, B-R-Y-A-N-T. Mr. Bryant was Mr. Anstat's direct supervisor and is our chief operating officer, was at the time as well. And then has some further emails on the topic that take us through to the November 13th official decision to retire Sibley after senior officer communications and board discussions. So that's what it is. I am on virtually all of these emails in here, so certainly was aware of the progression, the string that this email represents, as well as all other in-person or verbal discussions that happened with this team during this window of evaluating the Sibley forced outage.
Your Honor, this is a company response to an OPC DR in the complaint case. I believe Mr. has identified the materials, and I would ask for its admission as Exhibit 130. Sorry, 131.
I'll go with 130 because I think Ms. Whipple's earlier offering was only 88.
I think she offered 130
Okay.
and took away 88. So I would make this, excuse me, yeah, I would make this 131.
You are correct. Okay, you have heard the offer by Mr. Steiner. Exhibit 131, which is the KCPL GMO response to the data request 1039.
Correct.
Are there any objections to the admission of that exhibit? Hearing none, so admitted.
That's all I have, Your Honor. Thank you.
Thank you. Mr. Ives, you are excused.
Thank you.
Just a quick note, it is 11 o'clock. I do intend to break a little bit before noon, 5 or 10 minutes, give or take. And we have 6 witnesses by my scorecard remaining. Evergy, call your next witness.
Evergy calls John Reed to the stand.
And that was Mr. Zobrist. Mr. Reed is proceeding to the stand, and Judge Hatcher will swear him in. Please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Please have a seat. Evergy, your witness.
Thank you, Judge. Please state your name.
My name is John J. Reed.
And where are you employed, sir?
I am employed at Concentric Energy Advisors, Inc.
And what is your position there?
I'm the chairman and chief executive officer of the company.
Mr. Reed, have you prepared in this case surrebuttal testimony that has been marked as Exhibit 124?
Yes, I have.
Do you have any corrections or changes to that testimony?
No, I do not.
And if I were to ask you those questions, would your answers be as set forth in Exhibit 124?
Yes, they would.
And were your responses given under oath?
That is correct, they were.
Judge, at this time, I offer Exhibit 124 into evidence.
Counsel, you have heard the motion by Mr. Zobrist. Are there any objections to the admission of Exhibit 124? Hearing none, it is so admitted. Go ahead.
Thank you, Judge. I tender Mr. Reed for cross-examination.
Thank you. And again, we'll read through the excused parties quickly. Charge Point, Google.
No, Your Honor.
Nucor,
No questions, Judge.
Velvet Tech,
No, Your Honor.
City of St. Joseph, Dogwood, Sierra Club, Renew Missouri,
No questions, Your Honor.
Staff Counsel,
No, thank you, Your Honor.
MIEC, and next, Mr. Opitz with MECG,
No questions, Judge.
and Mr. Kleiser with OPC.
No questions, Your Honor.
Thank you. That brings us to commissioner questions. Are there any commissioner questions for Mr. Reed? Hearing none, the bench also has no questions. And And I believe that takes us to redirect.
I'd love to ask some redirect questions, Judge, but I don't think I'm going to be able to do that without a lot of objections.
Thank you. I will overrule myself and we'll move on.
Thank you, Mr. Reed.
Thank you. I appreciate the help, Mr. Zobrist. Let's move to staff's witnesses.
Your Honor, could I interrupt? This is Roger Steiner.
Yes.
The parties and the commission were gracious enough to waive the cross of Mr. Clote and would like to get his testimony admitted into the record. Could I do that now?
Yes, please.
I believe it's Clote Direct, Exhibit 44, Clote Rebuttal, 45, Surrebuttal and True Up Direct, 46, True Up Rebuttal, 47, and
115.
115 in the West case.
Which is 0130 for our future court reporter.
Right.
Okay, as I do normally, we will combine these. Does anyone have any objections to the admission of the 5 different Clote testimonies? This is exhibits 44, 45, 46, 47. Those are in case ending 0129 and exhibit 115 in case ending 0130. My question was, any objections? Hearing none, they are also admitted. Go ahead.
That's all I had, Your Honor. Thank you.
Oh, yes, we're just admitting the exhibits. Thank you. Let me take a second and make sure our number's written down. Okay, our next witness is from staff. Please go ahead.
Staff calls Keith Majors to the stand.
Thank you, Mr. Majors. If you'd raise your right hand, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please have a seat. Staff, your witness.
Could you please state and spell your name for the record?
Keith Majors, Keith, Majors, Majors.
And who are you employed by and in what capacity?
The Missouri Public Service Commission. I'm a utility regulatory auditor in the auditing department.
And did you prepare or cause to be prepared in these cases direct testimony, which has been marked as Exhibit 218?
Yes.
Rebuttal testimony that has been marked as Exhibit 254 in public and confidential versions?
Yes.
And then surrebuttal and true up direct testimony that has been marked as Exhibit 269.
Yes.
Do you have any corrections or changes to that testimony?
No.
And if I asked you those same questions today, would your answers be the same?
Yes.
And is that information true and correct to the best of your knowledge and belief?
Yes.
At this time, I would go ahead and offer those exhibits.
You've heard the motion by Ms. Mers. Are there any objections? And again, we will take these up as a combined question. Any objection to the admission of Mr. King's testimony, I'm sorry, Mr. Major's testimony, 218, Exhibit 254, and Exhibit 269? Hearing none, so admitted.
I would tender the witness for cross then.
Thank you. And again, we will go through some of our excuses rather quickly. Charge point, Google.
No questions, Your
New
Honor.
Corps.
No questions, Judge.
City of St. Joseph. Dogwood. Sierra Club. Renew, Missouri. Velvet Tech.
No questions, Your Honor.
Thank you. Evergy.
Yes, please, thank you.
Go ahead. And this is Ms. Whipple.
Ms. Whipple.
Whipple. Go ahead, I'm sorry.
Thank you.
For our future report reporter.
Mr. Majors, there has been discussion in testimony in this case of staff's true-up accounting schedules from the company's 2018 rate case, correct?
Yes.
And in this proceeding, MECG witness Greg Meyer relies on those accounting schedules to argue that the Sibley net book value should be $300 million. Is that your understanding?
Yes.
In the 2018 rate case, did you serve true-up discovery?
I believe so. I was involved in most, if not all, of the discovery in the entire 2018 and 2016 rate cases.
Permission to approach, please, Judge.
Granted.
Mr. Majors, did you serve data request 27T to Evergy 2018 rate case, case number ER-2018-0146?
Yes.
And did this true-up request seek all updates through the true-up period June 30th, 2018?
Yes.
Is this the response that you received from the company?
In part, yes. This is it's not really the face sheet, but the Word document description with the text of the data requests that's provided along with the actual information in Excel format.
This is the written response, but you, of course, have noted that there were Excel attachments to this response.
Yes.
And I have not provided those for saving the trees purposes, but I have circulated the written response. Is that correct?
Yes.
Could you please read the written response?
Your Honor, I might have an objection. Can you give me one moment, though?
Yes, that was Mr. Kleiser. Take a moment.
I'll go ahead and lodge the complaint. Again, that this is hearsay. The statements being made are being made by Evergy's witness, not by this witness. Therefore, they are out-of-court statements being offered to prove the truth of whatever is being said.
Can you distinguish this request to admit a data request from the data request just a few minutes ago that you said was offered in accordance with the earlier commission order?
Actually, I'm not sure which case was cited in the commission's order, to be honest. That was a different case. Are you shaking your head because this case is that one, or?
Yes, it is a different case. Let me check the order.
Frankly, Your Honor, the other document would have been hearsay too. I didn't object to it, A, because I chose not to, and B, because Dr. Mark did reference it, and I felt like the rule of complete evidence would probably have allowed it in anyways.
Okay, this is Judge Hatcher, and I'm reading from page 6 of the procedural schedule order. Ordered paragraph 6, sub H. Data requests and responses thereto made by any party in file numbers, I will only read the last 4 digits, 0200. The list continues, but I do not see 0146. Okay, so that brings us back to Public Counsel. Mr. Kleiser has raised an objection that a prior data request response is hearsay. And you, go ahead.
We disagree with that, Judge, but in any event, we aren't offering this for the truth of the matter asserted. We are offering it to establish that staff asked for and did receive this response to a data request.
If that's the only use for it, then I agree it's not hearsay.
I heard Mr. Kleiser say he withdrew his objection.
Assuming that that is in fact the only purpose for which it's being offered.
Go ahead, Ms. Whipple.
Thank you. Mr. Majors, could you please read the response that you received to this data request?
I'm going to assume you want me to start at the bottom of the page, front page.
Yes, please,
Okay.
where it says response.
1 and 2, in parentheses, for KCPL Greater Missouri Operations, please see the attached spreadsheet below. And reserve data provided as of June 30th, 2018. Production plant depreciation reserve is not maintained by individual generating unit except for IATAN Unit 2. Depreciation reserve reported in DR data request 0027T has been allocated to each generating unit except for IATAN Unit 2. Response prepared by Larry Mulligan.
Thank you. And then you noted earlier that it also states that there are 2 attachments. Of course, Mr. Mulligan's verification and plant and reserve data June 2018, which was an Excel file, correct?
Yes.
And do you recall receiving those along with this, although I have not duplicated them in paper form here today?
Yes.
Thank you. Judge, at this time, I'd like to offer this as Exhibit 132 in the West rate case.
You've heard the motion by Ms. Whipple. Are there any objections to the admission of Exhibit 132, which is data request and response 0027T from case number ending 0146?
For the record, as long as it is only being offered to establish the fact that the staff asked for and received updated depreciation information, I don't know exactly what the word I want is, then I have no objection. Otherwise, I object on the basis that it's hearsay.
Hearing no objections, Exhibit 132 is allowed for the purpose of showing that staff asked for and received said documents that are mentioned in the data request.
Mr. Majors, is it true that discovery in the 2018 rate case necessarily occurred before the commission issued its report and order in that case?
Yes.
And was the petition for an accounting order filed by OPC and MECG after the commission's order in the 2018 rate case?
That's my recollection. I can't tell you the exact date, but it was after the commission order.
Would you agree that sitting here today, you don't have a reason to dispute the veracity of this data request response?
No, I don't have I don't dispute the data request response.
Are you aware that a non-unanimous stipulation was filed in this proceeding on August 30th, 2022?
Yes.
And there was a public version filed as well as a confidential version, correct?
I'm gonna assume that's correct. I don't know that there was a confidential information in it, but I know it was filed.
Okay, permission to approach, please. Judge.
Go ahead.
Thanks.
Mr. Majors, is this the public version of the stipulation and agreement filed in this proceeding on August 30th, 2022?
Yes, it would appear to be yes.
And I will just note for the record that I did not include all of the voluminous schedules that were attached to this document, but of course, a part of the record in this case. Can you please turn to page 10?
Yes, I'm there.
Do you see paragraph 11, which is entitled Depreciation Rates? It has 3 subparts, A, B, and C.
Yes.
Could you please read subparagraph 11C?
The company will record and track depreciation reserve for generating facilities on an individual unit / location basis.
Is it your understanding that the company's fixed asset system, its plant accounting system, had not historically been tracking depreciation reserve on an individual unit and location basis?
My understanding from both the prior data request responses in the current and prior cases, that would be true for generating station plant, not necessarily distribution and transmission.
And is that why parties put this language in the stipulation so that the company could start to track by the unit and location level?
I really can't comment on why the parties put this information in there for their various reasons. I don't know that I could comment on that.
Yeah, I'm going to say this is coming dangerously close to discussing settlement. I'm not objectionable to what she's asking, but just keep that in mind.
I was just asking for the witness's understanding as to why this language exists in the stipulation and agreement.
I think he's answered that he doesn't know.
Okay, thank you. Mr. Majors, since staff agrees that Sibley's net book value is the 145.6 million figure, you would also agree that the value of the AAO liability that should have been deferred based on the Commission's 2019 order in the AAO case is $49 million. Is that correct?
You'd have to tell me if you're referring to the portion of the AAO that's the expenses or the rate of return.
The value of the return collected on rates.
I think in what's currently in, well, what was presented in staff's true-up and in testimony in direct was the 49 million that you referenced. I think that I know that there's been some presentation on some comments I made. I think it would be logical if whatever net book value that the commission determines, either the 300 or the 145 or somewhere in between, that if the commission were to include the rate of return deferral, that it should be based on whatever net book value is calculated. So in answer to your question, staff supports inclusion of the 145 and the amounts in direct testimony are calculated. The 49 million is calculated based on the 145 net book value.
Do you agree that the amounts of operational and maintenance expenses, O&M, deferred pursuant to the report and order in the Sibley AAO case total approximately $39 million?
Yes, that was an update from staff's direct position or direct recommendation based on a response to a data request, the company's work papers, and information provided by the company. There were some adjustments made on filings and an order from a separate fuel clause adjustment case that reduced those numbers to what you said, the current 39 approximately $39 million.
Thank you. No further questions at this time.
Thank you, Ms. Whipple. Let's go to MIEC, which has been excused, and Mr. Opitz, MECG.
Thank you, Your Honor. Good morning, Mr. Majors.
Good morning.
Let's talk about your calculation of the regulatory liability. You calculate the return that was built. When you are calculating that, you calculated the return that was built into rates off of the company's unrecovered investment, correct?
I think what's book value of 145, that's what's in the calculation right now.
That's in your calculation. And you included approximately $39 million for O&M, correct?
As adjusted, yes.
And MECG also recognized that $39 million approximately.
I take your word for it. I don't know if originally it was 41. I think there were some adjustments, but I don't know if they dispute those adjustments. But if you're saying you support the 39, I wouldn't doubt that.
And you understand that Mr. Meyer calculated the return on a higher unrecovered investment, correct?
Yes.
And if the commission adopted Mr. Meyer's unrecovered investment value, your calculation of the unrecovered investment would be exactly the same as his?
Could you repeat that one more time?
Sure. If the commission adopted Mr. Meyer's unrecovered investment figures, your calculation of the unrecovered investment would be exactly the same as his, the return portion.
Oh, yes. I think maybe to interpret your question, if the commission allows a return of the return on from the last case, whatever the net book value is, that's what the return should be calculated upon, whether it's 145 or the 300. I think Mr. Meyer calculated on the 300. So it should follow. It wouldn't make any sense to use a net book value of 300 and calculate the return on, from the last case, on 145. It should be consistent.
If that were the case, your calculation would be equal to Mr. Meyer's calculation, correct?
Without seeing the math, yes.
The similar methodology
Yes.
approach, okay. And your position is that you want to offset the regulatory asset by the regulatory liability, is that right?
I think generally with staff's primary recommendation is that those two would offset, and you would have a relatively small amount that you would then amortize as an increase to, well, that was staff's direct position, but you would have a relatively small regulatory asset that you'd amortize over 5 years. I think if you changed either whether you include or exclude the rate of return deferral, or whether you increase the net book value, I think some change is warranted to reduce the sheer impact of those amounts.
So I guess the difference here between staff and your calculations and Mr. Meyer's calculations is you use about 100 million for net book value, and we use 245 million.
Yes, net of the depreciation offset, which I don't think any party has disputed. Yes, I would agree with that.
Okay. So there's a lot of similarities in the way we would approach this. It's just determining that net book value, and a lot of things flow from there in the different parties' positions.
Yes, neither one of us include that in rate base, the unamortized net book value, so that's another commonality between our two positions.
So now let's turn to the regulatory asset. Are you the staff individual who reviewed the calculation for that $100 million and approved it?
Are you referring to the 145 less the depreciation, but I think the calculation would be the 145. Is that what you're referring to?
Yes.
Okay. I did review the calculations, the data request, Mr. Spanos' work papers in both the complaint case and the current rate case. I reviewed them from an accounting and auditing perspective to see if I were able to glean a meaning of the 145. I think for a more granular discussion of depreciation methodology, those would be better asked of Mr. Cunningham, our depreciation expert.
I'm not sure if this is should be directed to Cunningham, Mr. Cunningham, or yourself, so I'll ask you, and if you can, just let me know. So is it your understanding that the unrecovered investment in Sibley in Mr. Spanos' testimony from the EC 2019-0020 case was based off of a theoretical reserve calculation?
Yes, I've read his testimony, and I can at least say that it's based off a theoretical reserve.
Are you familiar with a theoretical reserve calculation?
From a very high-level standpoint, yes.
Can you explain what a theoretical reserve calculation is?
It would be taking the additions throughout the lifespan and using current depreciation rates as if they were in existence for the existence of the plant. I can't give you much more detail than that. I think that would be more of a Mr. Cunningham response.
So So you don't know the actual formula to do a theoretical reserve calculation?
No, I can't, no.
Mr. Majors, did you work on the last Evergy West, I believe it was GMO at the time, rate case?
Yes,
And are you familiar with accounting schedules and how they function in the context of setting rates?
yes,
Your Honor, may I approach?
Yes, go ahead.
Yeah, I think I got a copy here for you too. Mr. Majors, would you agree that that is staff's true-up accounting schedules from the prior Evergy West rate case?
yes,
And if I could turn your attention to the page for plant and service, which is Schedule 3, page 1 of 11.
I'm there.
Would you agree, well, let me, could you look at the column, it's on the far right, Mo adjusted jurisdictional?
Yes,
And if you go to lines 22, that says total Sibley Unit 1 steam, and the value for that is approximately $40.7 million.
yes,
And if you go to line 31, total Sibley Unit 2 steam, the Missouri adjusted jurisdictional, the value there is approximately $38.5 million.
yes,
And if we go to line 40, which is total Sibley Unit 3 steam, the Missouri adjusted jurisdictional amount is approximately $302.4 million.
yes,
And if you could turn to the next page, look at line 49, which is total Sibley facility common steam. You'd agree that the Missouri adjusted jurisdictional amount is $94.8 million.
yes,
And I don't know if you have a calculator, but subject to check, if I added those up, it would be $476.4 million.
that's what I have.
Okay. Now, if you could look to Schedules 6, page 1 of 11, which is the accumulated depreciation reserve schedules.
Yes,
If we look at the same Missouri jurisdictional amounts for lines, the corresponding lines there of 22, total Sibley Unit 1 steam is approximately $23.8 million.
yes,
For line 31, total Sibley Unit 2 steam, approximately $21.7 million.
yes,
Line, I believe, 40, total Sibley Unit 3 steam is approximately $96.2 million.
yes,
I think we go to the next page now. Line 49, total Sibley facility common steam. The amount there is $34.8 million.
Yes.
And subject to check, would you agree that adding those up equals 176.5 million?
That's what I have.
So if I were to subtract that 176.5 from the original plant and service value of 476.4, that equals 299.9. Would you agree?
Yes.
So would you agree with me that referring, if you go back to the accounting schedule, page 1, line 1, which is the net original cost rate base,
Yes.
and that is, I think, $1.9 billion. Is that right?
Yes.
That value includes that 299.9 million of unrecovered investment as depicted in staff's accounting schedules, correct?
Yes.
And those schedules were used to set rates and apply the rate of return to.
Yes.
Can you show me anywhere in these accounting schedules where the 145 value that the company and staff have used is in rates?
No.
Or any subsequent case, can you identify where that 145 would have been in rates?
I think that this is the subsequent case, and no, it's, I think it's on the company schedules, but that's only because they calculated it.
That's all I have. Thank you.
Thank you, Mr. Opitz. Mr. Kleiser.
Before I begin, Your Honor, you had mentioned something about wanting to break. I'm not sure I'm going to take 10 minutes. Is that up to you?
You're not sure if you're going to...
Take more than 10 minutes. I thought you said you wanted to break it like 5 till.
Yeah.
He's going to have to be called back to the stand either way.
Let's go ahead and take our break now. Yes, and we will come back at 1 o'clock. That is our break for lunch. And when we return, it'll be Mr. Majors on the stand with our final cross-examination by Office of Public Counsel. Just to verify, Mr. Opitz, you did not offer that document, correct? We'll still be on this topic after lunch.
Your
We'll
Honor,
come back to it.
I would like to, but I have not provided a copy to all counsel.
Yes, I noticed that.
So I can provide it electronically, or I guess I can go print out. It is quite a large document. So,
Your Honor?
it is filed in that prior case and was admitted into evidence in those cases. Could the commission take administrative notice of that accounting schedule?
We could, but we prefer to have it as an exhibit. Let's see if Mr. Kleiser has a solution.
I was going to offer, subject to check, of course, but I believe that the entire document is actually attached as a schedule to Mr. Robinette's testimony. So it might be entered on that basis, but I don't know if that would solve Mr. Opitz's concern.
I'm going to take lunch, and we will revisit this at 1 o'clock, and we should have answers then.
Okay, let's go off the record. We are at recess. Everyone, please come back at 1 p.m.
And I would tell the judge basically.
The hour of recess having expired, let us go back on the record. A couple reminders. We do have all commissioners in attendance on the WebEx. Also, we are without a live court reporter for today's hearing. So just a gentle reminder to the presiding officer and all of the counsel and witnesses, please speak slowly and into the microphone. With that said, we left off with Mr. Majors testifying for staff, and we were to our last cross-examination party, Mr. Kleiser. Mr. Majors, as you take a seat, you were sworn in earlier this morning. I just would like to remind you that that's still applicable. Mr. Kleiser, your witness.
Thank you. And good afternoon, Mr. Majors.
Good afternoon.
All right, I'm going to ask you a series of questions. These are fairly simple, so not trying to be tricky. You're familiar with the Sibley Generating Facility, Units 1, 2, and 3?
Yes.
And it's accurate to say it's been fully retired at this point, correct?
Yes.
And in fact, Evergy has at least begun the dismantlement of the jetties, correct?
I believe it's complete, but they have begun it, yes.
That was going to be my next question. So it was accurate to say they have completed dismantlement?
Yes.
So it is accurate to say that the Sibley facility will no longer be used for generating electricity?
As it stands today, yes.
How familiar are you with depreciation issues?
Somewhat familiar.
I'm going to ask you these questions, but if you feel like I need to kick them to Mr. Cuttingham, then just let me know. When a plant is first booked, you book the initial cost to plant and service, correct?
Yes.
And as depreciation reserve accumulates, it's booked to a separate account, correct?
Yes.
And the net book value of a plant is equal to the initial plant and service less the accumulated depreciation less any net.
Generally speaking, yes.
And that net book value is what is then put into rate base? Generally speaking.
Along with the whole group of assets, yes.
And that's what the company is allowed to earn a return on, correct?
Yes.
And if I were to hold the initial cost in plant and service constant, and I were to hold net salvage constant, so I'm only modifying the accumulated reserve that has been collected. If I increase the amount of reserve, I decrease the net book value of the plant, correct?
Yes.
And that would lower the amount that the company would earn a return on.
Yes.
And conversely, if I decrease, let me start over so it's clear. Conversely, if I decrease the accumulated depreciation reserve that has been collected, I would increase the net book value.
Yes.
And thereby increase the amount the company would earn a return on.
Yes.
Are you familiar with the RTO markets?
Generally, yes.
Would you agree with me that a utility operating in a market will generally sell all of its available generation into the market and then purchase back the energy it needs to operate?
Yes.
And if a utility has less generation to sell than it needs to purchase back, well, never mind. I apologize, Your Honor, that I think I actually am going to come in under 10 minutes. I'm very sorry. I have no further questions. Thank you.
Thank you, Mr. Kleiser. Now we turn to commission questions. Are there any commissioner questions for Mr. Majors of staff? And again, it is *6 to unmute if you are on a phone. Okay, hearing none, the bench does have a couple questions.
When Mr. Kleiser was talking about assigning the purchase price to an account and then also assigning the depreciation to an account or accumulated interest, I'm getting no help. When Mr. Kleiser was asking about assigning those different costs for Sibley at the time it was purchased or some imaginary theoretical plant, the answer was that it got assigned to such and such account.
Yes.
That account is from the U.S., what's the abbreviation? USAA? No? USOA, thank you.
Uniform System of Accounts.
Thank you. For electric companies.
Yes.
Do you know when that was established?
The Uniform System of Accounts?
Yep.
I would hazard a guess, probably sometime in the 1930s. That would be a guess. I don't know when it was established for use by the commission for determining rates. Probably around the same time, but that would be a guess.
What I'm driving at is the difference in time when Sibley was built was 60-some years ago. And so I'm trying to get to, would that have been in the same, would that have followed the same course under the USOA, or has that rule changed? As I think Mr. Spanos had kind of mentioned, that they changed from the life, was it life expectancy, I think? So I'm just wondering if there was a difference there.
Okay, so to answer your question in separate
Yeah, I'm
parts.
sorry, that was a terrible question.
I'll attempt to answer. So the plant instructions for the USOA would, where you book the construction costs would be in accounts 310 through approximately 316. And so that's where you would book the plant as an asset account upon purchase or construction. And so as you go through time, you would accrue a reserve by account, not necessarily by unit. You would accrue depreciation expense along with the other items that go into there as net salvage, things like that. But as that expense accrues, that, call it a contra account, would grow larger. I think what Mr. Spanos was referring to in change of depreciation method on lifespan or remaining life is, I'm using examples here, say if boilers account 312 was 4%, and then you would accrue to that account 4% depreciation reserve each year. So that's your return of that asset as the asset gets depleted by use or as time goes by, changes in the art, things like that. That's the consumption of the useful life of the asset. And so what I think Mr. Spanos is saying that the changes for remaining life or lifespan accounting would just be the change in that accrual rate of 4% versus a 3.5% or versus a 5.5%. That's what not necessarily an accounting change, but a change in the rate at which you accrue that depreciation expense that accumulates to reserve.
Thank you, Mr. Majors. My next question is I want to talk about the 300 million versus the 145.6. Would you walk me through how staff, let me set that back up. I understand that staff was recommending the commission use a $300 million net book value in the case, the 0200. And, sorry, I'll stop there.
You said staff recommended a 300 in the complaint case.
I think it was the complaint case.
Okay, just to answer that question, I think Mark Ogluschlager was the witness in that case. I don't recall that we supported the 300 net book value. I could be wrong about that, but there were several net book values. In fact, I've got the order. And in fact, I think the order references, if you'll pardon me a moment. Got the order from that complaint case. And as I said in my testimony, the commission did not determine what net book value to use. On page 9, paragraph 21, I'm reading here from the order. The estimated net book value of each Sibley unit and the common assets at Sibley as of June 30th, 2018, as calculated by GMO witness, is $145.7 million. Public counsel's witness estimated that net book value at $160 million, while MECG's witness estimated that value at $300 million. While this order doesn't mention staff, I don't know that staff did not have an opinion, but I don't recall that staff had one, and it wasn't in this paragraph in the order.
Was there any was there any movement from staff from supporting or using a $300 million figure to the 145?
Okay, I can certainly comment on that. Staff, I reviewed the EC case in which the 145 was calculated. That was the value we used for the direct filing. We reviewed, as you do, testimony, and as from other parties to get, the specific issues on the differences of the issues. And so I did read Mr. Meyer's testimony on the 300 million. I went back to the last case and did see that 300 million was the calculated net book value based on taking the plant less the reserve as appeared in staff's accounting schedules. I looked to see if there was any way, what's the right value? So, and is there a right value, more importantly? We talked internally, and I guess as a staff came to the conclusion that there's no real way, we didn't have really any good arguments against the 145, and we were being told by the company that the 300 is based on a simple allocation of the reserve, which was not recorded on a unit-specific basis. So you've got that. I also did, as not as a depreciation expert, but as an auditing and accounting expert, I went back to the 2004 rate case, which was the most recent, or the oldest that was still available on EFIS, and looked at staff's accounting schedules to see if I could rebuild and do an estimate of using those original plant values, not original plant values, but back to 2004, the oldest we could get. Could I take those from case to case and rebuild a estimated reserve based on plant and service, the original reserve as of 04, and taking the plant and depreciation accruals from case to case to estimate what would the current reserve be, just using the rates that were accrued from staff's accounting schedules. And I came up with just a high-level calculation, not getting into the things that Mr. Spanos would do. My net book value that I calculated high level, would be around $234 million. That's using, if I were to go case to case, using the commission ordered depreciation rates and the plant and service on the accounting schedules, calculating the accruals between rate cases, that's the number I come up with. And so, to sum it up, I think I respect Mr. Spanos's expertise as a depreciation expert. I can't recalculate the 145 million that he arrives to. But on the other hand, I don't dispute the company saying that what was what the reserve in the 2018 case was not assigned to that plant. It's an allocated reserve. I can't, I have that fact. So, I think the 145 is probably the best estimate based on expert testimony that we can see.
Just to make sure that I'm following, you're testifying that staff did not necessarily go from a 300 million to a 145 in their position. The 300 million was brought up in the other previous case, the 0200, the complaint case for the AAO. And then as you went through the testimony in this case, you attempted to recreate any number, and what you came out to was 234 million. But given your expertise is not in depreciation, and it was a high level, you're saying that was within your, maybe not comfort level, but you didn't have enough information to say you were absolutely more correct, and you didn't have enough information to say that Evergy's 145 million was incorrect, so you can accept theirs.
I think that's a very accurate description of what the thought process was. And another point, when you look at the 300 million, it just, and this is the highest level you can get, it doesn't make a whole lot of sense that a 60-year-old unit would still be 2/3 undepreciated. And so that's what you would, if you believe the 300 million net book value, then you believe that depreciation over nearly 60 years for units 1 and 2, and unit 3 was vintage 1969. That would be, 31, 58 years-ish. And so even with, and I think it was discussed earlier, there was two high-level improvements to Sibley. One was in the late 80s, early 90s, the Western coal conversion that I think you discussed with Mr. Spanos earlier. That was to convert it from using the high sulfur coal to the low sulfur coal. The other being in the 2009-2010 timeframe, when the selective catalytic reduction equipment to control SO2 emissions, NOx, nitrous oxide emissions, was installed in the unit. That was approximately $109 million. And I believe there was some precipitator work to control particulate emissions in that same time frame. But even with those improvements, you're still faced with, if you believe them in the 300 million, it's still 2/3 undepreciated. That on high level doesn't make all that much sense.
Is there any advantage to shareholders or ratepayers for making the $109 million improvement and then setting perhaps an artificial depreciation
date of 40 years longer? Is there any to the previous Public Service Commission assigning a depreciation schedule that I think we're now arguing was too long?
Okay, I think you're saying was there any benefit or was there any motivation to set?
Could there be?
No, I mean, I don't dispute, I believe the extended useful life, and somebody will correct me if I'm wrong, was 2040. I think generally you would use that retirement date to set depreciation rates. Again, I'm not a depreciation expert, but when you're developing remaining life depreciation rates, you would take that retirement date into account. I don't think there was anything nefarious either way in setting rates, depreciation rates too high or too low. Evergy, in consultation with its own internal engineers and outside experts, they determine for unit by unit, when do we think we can operate this unit profitably, safely, and within laws and regulations, and that date is used to project out what's the recovery period, what's the proper recovery period, and it's never going to, like anything else, it's never going to be perfect. So I would suspect that every unit will have some net book value at the end of its life. In fact, as a contrast to where we are here at Sibley, the Montrose unit, which was a 3-unit site, Montrose 1 was retired, I think, in 2016. Montrose 2 and 3 were retired at the end of 2018. Not a dissimilar site, 3 units, approximately 160 megawatt apiece, vintage late 1950s, old, somewhat, less efficient than other generating units on the system, in need, if continued operations would happen, in need of substantial investment in environmental equipment. And so, according to the company's IRP, it did not make a lot of sense to keep those units running. And by the same token, in comparison to Sibley, they still had a substantial net book value on the books. Now, that net book value for Montrose was not separately calculated by Mr. Spanos or any other depreciation expert. It would have been simply buried in the depreciation reserve. So it's kind of it's a contrast between where we are at Sibley, because it had another 20 years of life left, whereas Montrose, I don't believe, did, or at any time, or in the near past, those units were just expected to be retired because of their age, efficiency, and the investment required to keep them running.
Thank you. That cleared a lot up. I think I was confused on the 40 years with the 2040. But just one small detail. Thank you. And I'm sorry, that is going to open this all back up to recross and redirect. We're going to keep you up here a little bit longer. But thank you, Mr. Majors. You're doing a great job. That will take care of bench questions. Let's go to recross, and let me find my handy new schedule. Again, we will go fairly quickly for our new court reporter and those in the court. Charge point, any questions? Google?
No questions, Your Honor.
Nucor?
No questions, Judge.
City of St. Joseph. Dogwood? Sierra Club? Renew Missouri?
No questions, Judge.
Velvet Tech?
No questions, Your Honor.
Evergy?
excuse me, briefly.
Yes.
Jackie Whipple again for the company. Mr. Majors, you were discussing with Mr. Opitz and then with Judge Hatcher the different accounts with the company and how rates are set, trying to make that general. You recall that conversation?
Yes.
Isn't it true that the individual unit plant balances and reserve balances don't have an impact on setting rates?
Because they are all grouped together, yes, I would agree with that.
Yes. So in other words, only the aggregate amounts of reserve balances are used to set rates. Isn't that right?
Yes.
And so isn't it also true that Mr. Spanos's unit and locational calculations would not have impacted the aggregate balances that were used to set rates in the last rate case?
No, I don't believe they would impact that.
Thank you.
Thank you. That will take us to excused party MIEC. Next is Mr. Opitz with MECG.
Briefly, Your Honor.
ahead.
Mr. Majors, you were discussing your calculation to get to a $234 million value with the judge. Do you recall that?
Yes.
Can you tell me what time period you used in making that calculation?
So what I did was, I went back to the 2004 rate case, which the plant cut off, I'm sorry, ER-2004-0034, when it was still Aquila. The plant cutoff was September 30th of 2003. I'm sorry, does that answer your question? I can describe the other cases as well.
So you started there, but up through when, I guess, that length of time?
I cut off at the 2018 rate case, and so what I did was I used the beginning reserve. Back then, it was 2004 was $127 million, and used the authorized depreciation rates on the plant and service, accrued that depreciation until next rate case when rates would have changed. That would be the 2006 rate case, and went rate case to rate case using those plant balances, accruing the depreciation, and then adding that up. And then the second step was to for the interim additions between case to case, I used the average of the plant balances, the difference. So if you had a plant balance in 2006 versus 2004, take the difference, divide by 2, you assume ratably that the plant was added, and then you'd assign depreciation reserve based on the authorized rates. And so doing that, I would call it a simple exercise, would come up with around $234 million. But again, that's a simple exercise based on what was in staff's accounting schedules going back to 2004.
No more questions, Your Honor.
And Mr. Kleiser?
I'd like to start picking up where Ms. Whipple from Evergy left off. You, I believe, and I'm going to paraphrase here so make sure I get this correct, said that the reallocation, the theoretical reallocation Mr. Spanos performed would not have had an impact on the aggregate net plants. Did I get that right?
I think she had mentioned it was in the last rate case, and my interpretation was that, let's say you had your pool of reserve for generation only, let's just put it that way. If Mr. Spanos were to take that pool, let's say you have $500 million, and all he's doing is dicing it up, allocating it to certain units based on his calculations versus a very simple allocation based on relative amounts of plant. So it's just a ratio. I don't think, as long as your total pool of $500 million, my example, of reserve is still there, then there's no rate base impact, therefore no revenue requirement impact. But that's my interpretation of her question.
I'd like to run down that path just a little bit, if you're willing to bear with me.
Sure.
Let's, for the sake of this, let's assume a hypothetical, right? Let's assume that the utility has 2 generating plants.
Yes.
We'll call net original cost for both of them $6 million. Going to keep it simple.
Each?
Each. And we'll say accumulated reserve at $4 million each. All right, so the unrecovered balance, the net book value is $2 million each for these, right?
Yes.
So the total net book value is $4 million.
Yes.
What happens if the commission were to order that you couldn't earn a return on Plant A? How much would you earn a return on at that point?
I believe it would be the $2 million net book value of the second plant.
Which I'll refer to as Plant B to keep things simple.
Plant B, yes.
And if we reallocate the depreciation reserve so that we take $2 million from Plant B and put it into Plant A. Sorry, I'll have to move closer to the mic. If we reallocate that reserve, so we take $2 million from B and put it into A. So as I figured, it would be $6 million total depreciation reserve for A and $2 million total depreciation reserve for B.
I'm going to say yes, but I think one of those you said they couldn't earn a return.
Sorry, let's say that they're returning a return on both for just a moment.
All right.
Under that scenario, the total return, sorry, the total amount of plant on which they would earn a return, if they can earn a return on both, is still $4 million, right?
Yes.
And that's consistent with what you said. As long as you can earn a return on both plants, shifting the depreciation doesn't affect the aggregate plant that you earn a return on.
Right, nor does it affect depreciation.
But if I again come back and say they can't earn a return on Plant A, in the second scenario, you would agree with me that they're now earning a return on $4 million worth of remaining plant.
This is assuming you move the $2 million from A to B?
Correct.
Yes.
So by shifting the reserve from Plant A to Plant B, you increase the amount on which you can earn a return if you assume that there is no return earned on Plant A.
If you did those transfers, yes.
Thank you. Really quick, you had mentioned how you had come up with a 234. The 2004 rate case that you used, were you starting with staff's accounting schedules?
I was starting with the last known accounting schedules. I went through each case and determined if there was a stipulation or an order and whether or not depreciation rates changed or they were stipulated or ordered. And for each case, I went to the, it was typically, I think for these first two, there was no true up. Since then, there's been some true up. So to answer your question, yes, I used the latest, greatest staff accounting schedules. Those were the earliest ones that I could appropriate on EFIS.
Thank you. Now, in response to a question from the judge, you were kind of explaining why you decided to go with Mr. Spanos' number versus, say, what MECG has put on. Do you recall that?
Yes.
And again, I'm paraphrasing. I'm trying to do it well, but you'll correct me if I do it wrong. Your answer was effectively you couldn't verify Mr. Spanos' number, but the company had told you that the 2018 rate case numbers were based on a general allocation of reserve, and that's why you went with it.
I think that's probably a very condensed version. I'm not gonna disagree with that.
What I want to confirm is that it was staff's position based off the company's representation of the 2018 case that effectively decided that you would agree with Mr. Spanos.
Not entirely. Other prior responses to DR-27 have said that it's not allocated. Those reserve amounts aren't allocated by unit. And so, yes, the 300 is there, but my understanding is it's just based on the ratio of a relative plant to, say, Sibley to Jeffrey to Iatan 2, and then you take that up, you find the ratio of the plant to total plant, and then you multiply that times the total reserve for the steam units.
All right, one last line of questioning, I think. You had mentioned it not making sense that a 60-year-old plant would still have 2/3 of its depreciation. Do you recall that?
I would say in this scenario, yes, it just doesn't make sense at a very high level.
And so would your conclusion be that the depreciation rates that have been set in the past were inaccurate?
No, I think, no, I don't believe they were inaccurate. I think they were calculated using the best information that they had at the time.
Would the same hold true for the other generating facilities? Non-Sibley.
What would hold true?
Could there be an under recovery for all of the other facilities?
I suppose there could. I don't know. There could be.
And finally, when you make that statement, what method of depreciation are you using to come to that conclusion?
The 2/3, oh, that's just a simple calculation of taking the 18 case, the 476, which I think we've all discussed, versus the 176 in reserve. That gives you the $299.9 million. If you take the 176 divide by the 476, that gives you a 37% reserve to total plant, and then the one minus that number, reciprocal, I think, would be 63%. So 63% of the total plant would be unrecovered at the time of retirement. That on a very high level, that doesn't make a whole lot of sense in this example.
No further questions. Thank you.
Thank you, Mr. Kleiser. And we redirect Ms. Merz.
Okay. Nicole Merz for staff. I know you've walked through a few things a couple of times, but I think just to make sure that the record is clear and that all parties are on the stage, could you provide a concise, simple statement of what you look at to calculate a value for Sibley to then put in an EMS run? Because there's been a lot of debate over the 2018, 2004, the 300 number.
So I think to answer your question, let's go back to the 2018 case. We would request both in the direct filing and the true-up, what's called staff data request 27. It's a standard data request. It's been probably for the last 30 years. We would obtain that information. We might have some follow-up data requests on that, but that information would go into staff's accounting schedules. Schedule 3 is plant and service. I believe Schedule 6 is accumulated reserve. And so we would obtain that information by unit in most cases. I think it's gotten more detailed as of late in terms of separating the units. But we would include that in staff's accounting schedules, and that's how net plant and service and consequently rate base and the return is calculated.
So again, when parties were questioning you on the various figures for net book value in this case, the potential for the various components and offset, does that lead to the fact that there are that many different numerical values being suggested as the correct net book value?
Well, quite honestly, there wasn't a lot of questioning until this case on the reserve that we put in accounting schedules. I think there is now. And again, honestly, at the bottom of that page where it says reserve isn't allocated by generating unit, that was just kind of more or less an aside. But to your point, if there's belief in that number, I mean, that number is explained by what the company has said. I don't dispute that. But the number identified by Mr. Spanos is calculated based on his methodologies and techniques to develop that number. So there is a wide of what is the correct number. Is there a correct number that's accurate?
So would it be correct to restate what you just said, is that it's just not as simple as going to the 2018 EMS run and pulling that figure?
No, I don't think it's that simple, and it's I think if you take that in context with what I've done and went back to a high level, do some kind of verification of that, I don't come up with 300 million. I actually went farther than this, and I went and looked at but I pulled the information when IATN-2 came into service in 2010, in the subsequent 2012 cases, and obtained the plant and service and depreciation reserve. On the contrary, with IATN-2, because it is recorded on a unit basis, the build out of depreciation calculated was right on top, very close to what the company had in the 18 case. And so if I were to take that from the 2010 case through the 18 case, take the IATN-2 using authorized rates, building out the reserve, I came very close to what was actually recorded as of June 30th, 2018.
And so the fact Sibley was not, at least in past cases, put in an or accounted for in an unit location, individual unit location, I think is the term that's been used. Would you think that explains the fact that the commission couldn't order in the EC case a set value for Sibley?
Well, I think the reason the commission couldn't order, I think the reason the commission couldn't order a set value is because, well, they had the ability to order a set value, but it wasn't a necessarily requirement of the AAO case. And in fact, they did not order the specific O&M deferral or the net book value because the AAO case was simply a determination of whether or not this event was extraordinary and whether or not the company should defer amounts on their books and records. But I think the reason why no net book value was determined was because there were at least 3 opinions on what the net book value should be. And so my understanding was the commission wasn't required to determine a net book value in that case, nor was it required to determine the prudence of the retirement of Sibley, which they noted in their order.
And would you think it's fair to say that in the you said there's at least 3 positions? In this case, would you agree there's at least 4?
Yes.
And then in the 2018 case, I believe you testified in response to questions from various parties that you were involved in that. Counsel for MECG even brought up the EMS run that you had been a part of, correct?
Yes.
And did parties present multiple positions on that value in that case before it was settled?
My recollection, well, the 2018 case was, I believe it was a settled case, and that was, part of the driver was tax reform. I don't recall that the net book value was an issue at that time. I think I think, I'm not going to talk for OPC, but I think they did take some issue with the pending retirement of Sibley. But I don't think the net book value was an issue at the time of the 2018 rate case.
You, in response to some questioning from the bench, you were asked about at what point in time you had reviewed the 300 million figure versus coming to the 145.6 figure. In your evaluation and evidence, other than what you explained to the judge, were there any other problematic or reasons that you thought that figure, you couldn't rely on that as opposed to the 145?
I think other than what I've said about the very high level, it doesn't make sense that it's 2/3 undepreciated. No, I don't think there was any other reasons why, that the 145 was preferred over the 300. I think it's important to note that in rebuttal, I said the commission should consider and could consider the 300, but staff's recommendation and what has been in staff's revenue requirement models has always been the 145 and the other calculations that are based on the 145.
So to maybe summarize and
I'm so sorry to interrupt. You keep moving this closer, but then you're engaging the witness and moving away from the microphone. And since we don't have a recorder here, I'm so sorry to ask you to move that microphone again.
Okay, I apologize. I will maybe just make sure somebody sanitizes it when I'm done, but I will get very close. Hopefully this is better. But I think I am almost done, so hopefully that helps. I guess to summarize it and kind of put it on a very layperson way of putting it, in your expertise and experience, being trained as an auditor, is it just fair to say that the 300 passed the spell test?
I don't know that I'd characterize it that way. I mean, the 300 is, there's no question that it's in the accounting schedules. There's no question that if you were to go back in time, that's what's in the books. That's what's as a response to the data request and is on the books records. But with the evidence and the testimony in this case, I would not use that number. I think that what I just said may contradict some of the things I've said in testimony, but staff's recommendation is to use the 145.
And then I think what would be my final question, but in your exam, or when you were being questioned by counsel for OPC, You were asked if you thought all plant could be under depreciated. That was in reference to your statement that you've made about it, Sibley being only charged depreciated didn't make sense. Did you do a calculation for any plant other than Sibley, or look at that information?
I looked at the information on the Montrose plant, and I do have that. And again, the Montrose plant was retired around 2016, March, and Unit 1 was March of 2016, my recollection of what this says here, and November of 2018 for Units 2 and 3. I did ask the company what was the net book value at the time of retirement. And similar to what is on DR-27 is that the statement that what comes out of power plan is just an allocation based on total reserve, total plant and reserve. And that net book value at the time of retirement for Unit 1 was $31 million. And Units 2, 3 in common was $137 million.
Okay. Apologies. Okay. For my last question, you were asked by the bench about the 145 in direct and then the mention of the 300 in rebuttal. Does staff continue to evaluate issues and evidence after filing direct?
Oh, absolutely. I think a great example of that would be the last Spire case where the Office of the Public Counsel brought the commission and staff's attention about a discrimination lawsuit settlement. And that was something that we were unaware of prior to our direct filing. So we supported removing those dollars. I wouldn't say that's an isolated example. I think other parties do bring matters to staff's attention that we were unaware of.
And that doesn't just continue through direct, but if something large comes to our attention in rebuttal, it's throughout the case.
Oh, sure. Another good example is in the 2014 case. We had something called Independence Power of Light transmission costs that were a new item in the true-up that we were unaware of until that time. And so we quickly hatched a position on that and determined what staff's position was going to be. And that was just strictly in the true-up. So, I think issues like this sometimes do evolve throughout the case.
Oh, thank you.
Thank you, Mr. Majors. You are excused. And staff, bring up your next witness, please.
Staff calls Cedric Cunningham to the stand.
Thank you, sir. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. Ms. Mers, go ahead.
Could you please state and spell your name for the record?
Cedric, Cedric, Cunningham, Cunigan.
And by whom are you employed and in what capacity?
The Missouri Public Service Commission, and I'm a professional engineer.
And did you prepare or cause to be prepared direct testimony that has been labeled Exhibit 209, rebuttal testimony that has been marked Exhibit 237 in both public and confidential formats, and surrebuttal, true-up direct
that has been marked as Exhibit 261 in both confidential and public versions?
Yes.
And do you have any corrections to make to that testimony?
No.
And if I asked you those questions today, would your answers be the same?
Yes.
And is that information true and correct to the best of your knowledge and belief?
Yes.
At this time, I would offer to admit those pieces of evidence or testimony.
Thank you, Ms. Mers. Council has heard the motion for the commission to accept Exhibits 209, 237, and 261. Any objections? Hearing none, they are so admitted.
I will go ahead and offer the witness for cross-examination.
Thank you, ma'am. Let's go to the presiding officer's handy cheat sheet. Let's go through the parties again. We will move through them economically as some have been excused. ChargePoint, Google.
No questions, Your Honor.
Nucor,
No questions, Judge.
City of St. Joe, Dogwood, Sierra Club, Renew Missouri,
No questions, Your Honor.
MIEC, and Mr. Opitz with MECG.
Judge, I'm still thinking about it, but isn't the order company is ahead of MECG on this
Oh,
one?
yes. My apologies.
And same for
Velvet.
Velvet.
Skipped right ahead. Let's go back to Evergy.
Yeah, thank you, Judge.
Thank you. And now we go again to MIEC. Oh, and Velvet Tech.
No questions, Your Honor.
Thank you. Mr. Opitz, I think we're back to you again.
I guess much ado about nothing. I have no questions now.
That's okay. I appreciate the exercise. Office of Public Counsel.
I also have no questions. Thank you.
Excellent. Thank you. And redirect. No redirect.
Yeah, not unless you or the commissioners would have any questions, Your Honor.
First, we'll ask the commissioners if they have any questions. Any commission questions for Mr. Cunningham, professional engineer?
No questions. No questions, Judge. Thank you.
Thank you, Chairman and Commissioner Holzman. The bench does have a few questions. The first, I'm going to follow up with one of my last questions of Mr. Majors. Can you walk me through the 300 million to the 145? Or perhaps more simply, do you support his answer?
I wasn't a part of the last case on how that 300 million was calculated, but I was able to see how it was calculated moving the 2018 balances forward. I was also able to calculate through the depreciation software how the company got to the 145.
Did you have a chance to review Mr. Meyer's testimony?
Yes.
I'd like to point you to Table 6, and that is on page 13 of Mr. Meyer's direct. Do you happen to have that?
I do not have that in front of me.
If I can approach, Your Honor, I have.
Please, go ahead.
All
Page
right, give me the
13.
position again.
Page 13, Table 6. And offering the testimony was Counsel Nicole Mers. That's for the future court reporters' notes. Okay, my question is, on that table, Mr. Meyer describes how the accumulated depreciation reserves of several other generating units has decreased between the amount presented in this case in comparison to staff's accounting schedules from the prior rate case. Does staff have an opinion about that reduction?
The reduction is due to the reallocation of the balances, the reserve balances.
I'm sorry, reallocation from the general to the specific generating units? Is that what you mean, reallocation?
Yes, so when Keith was talking, or Mr. Majors was talking, the plant balances for the individual FERC accounts are not tied to the unit or location, but the total balance for that FERC account would remain the same.
So to paraphrase in layman's terms, Evergy has been keeping the accumulated depreciation reserves in a one combined account for all of its generating units.
By type, so like steam generation is together.
Okay. And the normal course of business is that as a generating unit retires, and in the typical course of unit, that is usually within, I would say, maybe a few years or half a decade of the calculated depreciation point where the asset is fully depreciated. The normal course of business is to subtract out that portion from the accumulated reserve of that type, generating unit type.
Yes. As the assets would retire, they would be removed from plant and service and the reserve for those accounts.
And the hang up here is the presumed extra life added on to Sibley when the $2 million something repairs were done. And that has caused objections, which has now caused the parties to try and take the combined account and decipher out how much should be attributed or delegated to Sibley.
That is a part of it.
Give me the part I'm missing.
I think the big piece is that whatever is in the accounting schedules doesn't necessarily match up with a depreciation study for what those accounts should be. And Mr. Spanos calculated a theoretical reserve, which will tell you what that account should be at given the life parameters you have, like the age and the expected life expectancy. And so when those don't match up, as in a lot of our cases, we get a stipulation and it's never agreed to what the actual reserve balance is, but the final rate is what's ordered.
I'm going to look to counsel for objections before I let you answer my next question.
Would, in the normal course of business, then, is my understanding, and I do not get into settlement discussions in this case or any case, but in the normal course of business, Mr. Cunningham mentioned the stipulation. Would whatever that amount that is not known to the commissioners, again, just in the normal course of business, be a division between ratepayer recovery and shareholders? I don't want to get too fine a point on that, but is that kind of, okay, I'm way off
Waiting
base.
for objections, or?
Repeat the question, Your Honor.
I'm still trying to wrap my head around this, so I know that the numbers are never going to match up because it's a predicted life expectancy versus an actual life expectancy. And when that asset actually comes to its end, as I believe you're testifying to, is normally within a kind of a close range. Okay, and then we jumped off to that difference disappears into the stipulation and comes out on the other side with a number of what the rate base is and what the rate of return is. So my question is, understanding that the commissioners and myself are not privy to settlements, there's rule against us knowing about it, knowing the details, so I don't want those. But when we're talking about going through that process, is that process splitting up the difference that is unrecovered to then be, I don't want to trip on terms of art, associated to ratepayers or associated to shareholders? I think I'm going to move on. I withdraw the question. You've testified to the decrease in the accumulated depreciation reserves for the 5 generating units.
It's a reallocation of the total plant balance.
And does staff agree with that?
Yes.
I would like to turn to your SIR rebuttal, page 9.
Apologies, Your Honor, I missed which testimony you're referencing.
Mr. Cunningham's SIR rebuttal, page 9, lines 13 to 14. The testimony states, quote, "This resulted in a roughly $173 million increase of the steam production plant reserve balances from staff's current EMS run, comma, with Sibley plant removed, period," end quote. Here's my question. To confirm, are you referring to the steam production units as referenced in Greg Meyer's direct testimony?
Yes.
And the $173 million reserve balance amount is based on which date?
So for that amount, I took the 2018 accounting schedule values from True Up, and I applied the depreciation expense to those plants for the next, was it 3 or 4 years to get to current time, and then assuming 3.5% inflation, that's how I calculated the 173 million. But it's taking those 2018 true-up staff accounting schedules and moving that forward to current time, and then that is the difference between the 154 net book value estimates between the company, staff, and MECG. So one has a lower depreciation reserve for these accounts because the Sibley amounts are in there. If you take those Sibley amounts and put it outside, you have a higher net book value for Sibley, but you also have to increase the reserve for the remaining plants.
Why would you have to increase the reserve if theoretically each plant has contributed its depreciation reserve, but in the aggregate of that group?
It's the fact that you're removing Sibley for this case, or it's been proposed to remove Sibley from this case.
Let's get back to my date question. So 2018, and then you said you were to current time, and did you calculate that up to the true update of May 31st, 2022? Or perhaps,
I believe it was either May or June, but yeah, it would have been the true up period for this case.
okay. And are the calculations for your proposed value of the regulatory liability and unrecovered investment, are your calculations included in your testimony?
It was included in a work paper attached to my surrebuttal, but I don't think it was just out on the. It wasn't attached to the testimony, but it should have been included to a work paper to the parties.
The commission would also like to see a copy of Engineer Cunningham calculations. End of the day? Is that?
Yes, since we already have them, I don't believe it should be problematic
Okay.
for us to give that. And I apologize.
No.
Nicole Mers for staff.
No, yes, Nicole Murray, this is Judge Hatcher. I don't want to overburden you. Tomorrow's fine. We're going to be here. Let's call it tomorrow. With that, I have no more questions.
All right.
Hold on. Stay right there. I have now subjected you to stay up here for a little bit longer, and I apologize. Let's get to re-cross-examination. And again, for our future court reporter, I'm going to quickly read through this list. Charge Point, Google, Nucor.
No questions, Judge.
City of St. Joseph, Dogwood, Sierra Club, Renew Missouri,
No questions, Your Honor.
Velvet Tech,
No questions, Your Honor.
Evergy.
Yes, thank you. Mr. Cunningham, staff's rates are based on a Sibley net book value of $145.6 million as calculated by Mr. Spanos, correct?
Yes, staff and Mr. Spanos used similar calculation methods.
Thank you.
And that was Ms. Whipple.
Yes.
Next party is the excused MIEC. Next after that is Mr. Opitz, MECG.
No, thank you, Your Honor.
Mr. Kleiser, OPC.
Just briefly. Well, actually, I can't say that for certain. You were asked questions regarding this table in Mr. Meyer's testimony. And you were asked a series of questions regarding how all this math worked. And I feel like I'm going to make an effort here to try and simplify this. I'm also going to try and get closer to the mic. So let's walk back to the rate case in 2018. You with me?
Yes.
At that time, Evergy has several steam plant generation in plant. I use the word plant twice, but they have several steam generating plants. You got Jeffrey Energy, Lake Road, Iatan, Sibley, right?
Yes.
The net original cost of each of those is going to be booked to plant and service, right?
Yes.
And that's going to show up in the staff's accounting schedules, right?
Yes.
So the reserve. There's an allocation of the reserve amongst those facilities in staff's accounting schedules, right?
Yes.
And I don't want to get too deep into the weeds on how that allocation is done, but all we need to know right now is the accumulated reserve for those plants are allocated amongst the plants in the staff accounting schedules.
Yes.
So moving forward, in the 2018 complaint case, Mr. Spanos presented a different method of allocating that reserve. You say that's accurate?
I can't say that the method was different from what he presented in 2018. It was different from staff's accounting schedules and what was present in staff's accounting schedules.
The numbers were different. We can agree on that.
Yes.
And what we're seeing in this table 6 on page 13 is that between the 2018 rate case and the complaint case, reserve that was previously booked to Jeffrey, Lake Road, Iatan was removed and transferred. Would you say that's accurate?
On these schedules, that's the way it appears, but as stated earlier, the accounts are all mingled for the locations. And so I can't say that it actually changed in accounts, it's just the way that it appears on our tracking of it.
Sure, but you would agree with me that the numbers have gotten smaller. The reserve balances for those facilities have gotten smaller between the last rate case and this one.
Yes.
And if I add up all the difference and I compare it, it's roughly the same amount that was increased for Sibley.
Yes.
And you would agree with me then, if we turn to page 14, Evergy, sorry, I'm going to read the lines from Mr. Meyer's surrebuttal. Evergy has decreased the accumulated depreciation reserve balances for the Jeffrey Energy Center, Iatan 1 and 2, and Lake Road generating units to account for a portion of undepreciated balance for Sibley from the Sibley unit retirements. Would you agree with that statement?
I would agree with the effect. I can't agree with the reasoning.
Fair enough. If the commission determines to grant no return on Sibley, but continues to allow a return on these remaining plants, you would agree with me that the reduction in reserve and subsequent increase in net book value results in a higher return on investment for the company.
I'm sorry, that was a lot. Can you reword that again?
No, I agree, that was a lot. Let's try and break that down. In this case, you have, not you, but in this case, the amount of accumulated depreciation reserve for the remaining steam plant is lower than it was in the last rate case.
Yes.
The result is the net book value of those remaining plants is higher than it was in the last case.
Yes.
So the company will earn a higher return, or rather, the company will make more in the return on those remaining plants as a result of this.
I think the issue you run into with that is that, again, the accounts aren't actually segregated. So when you look at the total account balance, that remains the same. But because Sibley is being removed from that account balance, that's where you run into the issue. And I think I touched on it in my testimony that it's the timing of the reallocation that makes it seem odd. If this was done back in 2010, it wouldn't have been as big of an issue.
Are your depreciation rates higher because of the change in reserve allocation?
I did not run depreciation rates given the, I did not run depreciation rates with a 2018 moved, or Mr. Myers scenario. So I can't tell you if they would have been higher or what the magnitude of depreciation expense would be. It may change individual accounts, but I can't tell you what the total effect on, rate base would be.
The judge asked, sorry, had to turn the mic back on. The judge asked about your surrebuttal testimony and your calculation of the reserve adjustments. In that discussion, you said you started with the 2018 case. Do you recall that?
Yes.
Did you update plant for additions and retirements between June 2018 and until its retirement?
I did not do that for that scenario. I was just looking at the reserve balances. I did not include plan additions and retirements. It was a simple calculation of moving depreciation expense into reserve for those accounts.
If the reserve for an account is higher, how does that affect the depreciation rate of the remaining life?
If the reserve is higher, then the depreciation rate would be lower given the same time frame.
That would lower the depreciation expense that would need to be included in the case, correct?
Yes.
And conversely, if you lower the depreciation rates, if you lower the reserve, it would increase the depreciation rate?
Yes, given everything else is constant.
Which would also increase depreciation expense, correct?
Yes.
No further questions. Thank you, Your Honor.
Thank you, Mr. Kleiser. That will take us to redirect. Nicole Mers for staff.
In questioning from the bench, you were asked if the extension in life because of the $21 million repair was causing a disconnect between parties. Do you recall that?
Yes.
Do you recall, was that $20.1 million repair made in response to the forced outage in 2008?
I don't recall.
And do you recall if that forced outage had a large impact on the remaining life of Sibley?
Yes. From other testimony today, yes.
Is it your recollection that Evergy had announced a retirement date 6 weeks, that would have been 6 weeks beyond that forced outage?
I don't recall that.
Okay. I will maybe myself tread a dangerous ground here and try to get into anything objectionable and also, although the question was withdrawn, maybe help try to clarify where you were going, not to assume to be so bold, but let's see if I can make that happen. But do you recall being asked kind of about the mismatch that can happen between things being stipulated or agreed to in a settlement versus the calculations and figures that parties would use to kind of produce their revenue requirement?
Yes.
Is it your understanding, and of course you are not a lawyer, but is it your understanding that settlements are often black boxed?
Yes.
And is your understanding that means that a particular position isn't necessarily rejected or accepted?
Yes.
And in those situations, a party can kind of back into whatever that total figure is of their own accord.
Yes.
So one party may not want to include a plant and assume that that is all being borne by shareholders, while another party may think it is included in that black box settlement being borne by ratepayers. Is that your understanding of how that process would work?
Yes.
Okay. Hopefully, does that, okay. You were asked by counsel for OPC if Spanos had different results for the depreciation reserve in the 2018 case and the 2019 complaint case. Do you recall that?
Yes.
Are you familiar with the testimony of OPC witness John Robinette in this case?
I don't have it in front of me, but I've read it.
Do you recall how many methods to determine the Sibley balances he provides?
I think he provided 2 additional methods, but I think there were a total of 4 options.
And did those provide different results?
Yes.
You were also asked by OPC about the $300 million reserve that was proposed by Greg Meyer. He asked what the impact would be on depreciation rates. Do you recall that?
Yes.
Did any other party besides staff and Evergy provide depreciation rates in this case?
No.
Okay, that is all I have. Thank you.
Thank you. Mr. You are excused. I appreciate you coming up and testifying. That leaves us with 3 witnesses left, and it is 2:30, about an hour and a half after we started. This seems like a good time to take a break. Let's call it 15 minutes. Everyone come back at 2:45. The time has expired for our recess. Thank you, Dr. Mark. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Please have a seat. A little bit out of order. I'll bring everyone listening on WebEx and on the live stream up to speed. We have returned from our afternoon break. We have 3 witnesses remaining, and we have discussed recalling Mr. Spanos for any follow-up that might have occurred. We also discussed an exhibit for the rebuttal testimony of Mr. Spanos from the complaint file for the AAO, which was EC and ending in 0200. I'm ready for a motion from Evergy to admit Mr. Spanos's said rebuttal testimony.
So moved.
Are there any objections? Again, this is Mr. Spanos's rebuttal testimony from the AAO complaint case, which is, I forget the year, but it's EC and the
2019.
2018.
19.
19. I feel like an auctioneer, but it ends in 0200. Any objections?
No objections, Your Honor. Would it be possible to have leave to potentially file other late filed exhibits if other parties have response to Mr. Spanos's that was filed in that case, if you follow me?
I do, and that seems very messy.
I'm not asking at the moment that I actually be allowed to, just something that the commission will consider in the future if parties feel it's necessary.
Your Honor, it's our understanding this was requested by the commission.
I take your meaning. Mr. Kleiser, I'm going to leave that open, and let's see where we end up next Friday. No objections. The exhibit is admitted, and let's get to the number. I have 133.
That is our number as well.
Excellent.
And with your permission, I'll hand these out quickly. I've got the copies if you'd like them. Okay.
Yes, please go ahead. And for our future court reporter, that was Judge Hatcher speaking with John Kleiser of the OPC and Ms. Whipple of Evergy. And Dr. Mark has been sworn in. Mr. Kleiser.
Thank you. Dr. Mark, can you please state and spell your last name?
Mark? Jeff Mark, you want the full name, right?
Yes.
Okay. Jeff Mark, it's Geoffmarke.
Thank you. And by whom are you employed and in what capacity?
Missouri Office of Public Counsel.
And did you prepare or cause to be prepared testimony for this case, which has been pre-marked 306 for the direct testimony, 307 for the rebuttal testimony, both public and confidential versions, and 308 for the surrebuttal testimony of Dr. Jeff Mark, both confidential and public versions?
Yes.
And the answers that you gave in those pre-filed testimonies, the same. If I asked you the same questions today as were asked in those pre-filed testimonies, would your answers today be the same?
Yes, there would.
Do you have any corrections to make to those pre-filed testimony?
I do not.
With that, I'll offer the testimony of Dr. Jeff Mark. So that would be 306 for the direct, 307 for the rebuttal, both public and confidential, and 308 for the surrebuttal, both public and confidential.
You've heard the motion by Mr. Kleiser, as I usually do. Are there any objections to the admission of Dr. Mark's testimony noted as Exhibit 306, Exhibit 307, and Exhibit 308? Hearing none, so admitted. Mr. Kleiser?
I tender the witness for cross-examination.
That was too fast for me. I need to find my cheat sheet. Okay, and again, for our future court reporter, I will read through the excused parties with some economy of speed. Charge Point, any questions? Google.
No questions, Your Honor.
Nucor.
No questions, Judge.
City of St. Joseph. Dogwood. Sierra Club. Renew Missouri.
No questions, Your Honor.
The excused party, MIEC. Mr. Opitz, MECG.
No questions, Your Honor.
Staff. Velvet Tech.
No question, Chair.
And let's do Evergy.
Thank you, Judge. Carl Zobrist. Doctor, do you have available your direct examination before you?
Yes, sir.
Okay. Could you please turn to page 9 of your direct?
I'm there.
In answer to the question that is set forth on line 5, if you could go to your answer that begins on line 10, that states, in vertically integrated regulated states like Missouri, electricity prices are based on utilities' actual expenditures, and utilities have little reason to control costs because cost reductions ultimately are passed on to customers. Did I read that correctly, sir?
Yes.
Okay. Would you agree that only costs that are found to be prudently incurred by the Public Service Commission are passed on to customers?
Yes.
And so costs that are found to be imprudent are not passed on to customers?
That's correct.
Okay. Now, if you'd go to the line 13, it's the next sentence on that very same page. You say, additionally, regulators allow utilities to earn a specific, pardon me, I'll start again. Additionally, regulators allow utilities to earn a specified rate of return on capital expenditures to, and then you have in quotes, incentivize, close quote, investment in capital-intensive facilities. Did I read that correctly?
That's correct.
Okay. Now, is it true that a utility is not, same page, same answer, so page 9, line 13 through 14? That's what it says. Additionally, regulators allow utilities.
Are you on Metro?
Sorry.
Yeah. I'm sorry, this is in Evergy, Missouri West. It's the 130. Okay. Do you need a moment, Mr. Kleiser? Okay. Dr. Mark, is it true that a utility is not guaranteed a specific rate of return or a return on equity by the commission?
That is true.
Now, you put the word incentivize in quotes there. Is that correct?
I did.
Do you believe that the commission is not properly incentivizing Evergy or other Missouri public utilities to operate prudently with regard to their investment decisions in their capital facilities?
Oh, I believe that they provide a healthy return for utilities.
So why is the word incentivize in quotes in your answer?
It's in contrast to the free market example that follows that.
Okay. And in that following sentence that begins toward the end of line 14, again on page 9 of your direct in the Evergy, Missouri West, you say, quote, that is, comma, utilities have a perverse incentive to increase their capital investments, I period, E period, comma, rate base, period. Did I read that correctly?
You did.
So do you believe that Missouri statutes and policies that encourage electric utilities to invest in generation and other infrastructure is perverse?
I don't believe the statute is perverse. If I'm answering that correctly, I believe the opportunity is there for it to be, I don't want to say perverted, but distorted. We'll use that word.
So you believe that a competitive market doesn't have those flaws that our system here in Missouri has?
I think a competitive market has the market accountability to hold it accountable.
Now, Dr. Mark, is it generally true in the United States that those states that operate under a competitive basis, in other words, they do not have vertically integrated utilities like we do in Missouri, regulated as they are in Missouri, that their retail rates tend to be higher than those in Missouri?
In general, yes.
Now, on page 12 of this direct, if you could go there, please. Lines 21 through 22.
I'm there.
The question was, are there any benefits from stranding a coal plant? And you answered, quote, there are absolutely clear environmental and health-related benefits from the closure of fossil fuel generating plants. Did I read that correctly?
Yes, you did.
And so is it correct that the closing of Sibley provided those benefits?
It would.
And would you agree that a utility should not have to wait until the Environmental Protection Agency brings an enforcement action before a coal plant is shut?
I'm going to ask you to repeat that again so
Sure.
I can, thanks.
Would you agree with the proposition that a utility should not have to wait until the Environmental Protection Agency demands that it close a coal plant?
Each utility in each coal plant or fossil fuel plant, renewable plant is going to be on a case-by-case basis. I don't think I can generalize.
Okay. Now, in your testimony, just above where I was quoting on lines 11 through 19, you make a comparison between Evergy Missouri West, or at least electric utilities in Missouri, and the Ford Motor Company. Do you remember that?
I do.
Okay. Now, you state, I believe it is on lines 12 and 13, that it would not be prudent to, quote, shut down an operating plant that's more efficient, more productive, and cleaner than other operating plants. Is that correct?
Yes.
Okay. Therefore, if a less efficient, a less productive, and a dirtier plant is shut down, that would be prudent, correct?
Assuming we are shutting down a plant to begin with? I'm operating under that assumption.
Correct.
Given the option between shutting down an efficient, clean plant versus shutting down an inefficient, non-clean plant, yes.
Okay. Is your testimony in this case that the Sibley Unit 3 was efficient, productive, and cleaner than other operating plants in the Evergy Missouri West system?
It's a unique question that I would believe I'm going to need to qualify that beyond just a yes and no answer or response, if I may.
Go ahead.
Evergy Sibley Unit 3 was the only wholly owned unit within Evergy's system. There are dirtier plants within its footprint, Jeffrey, for an example. There are, in terms of efficiency and marketability, you know, what's being able to be sold into the SPP market. I caught just a little bit of Mr. Zorber's opening. In terms of whether or not a plant is profitable on a temporal level, you really need to look at it not only historically and when it occurred, but also what's happening in the market moving forward. And my testimony, both my direct, my rebuttal, my surrebuttal, my surrebuttal anyway, provided detail of comments that our office had made both in various IRP dockets, special contemporary dockets, and in previous rate cases, where amongst other things, we posited that a serious concern about reliability, the fact that there were more renewables coming online that would put a greater pressure on the marketability, the efficiency of having those baseload coal plants available. And I would say what I heard in agenda, this week.
Well, Judge, I think he's now going beyond an explanation of my question, so I would request that the witness conclude his question, because I've got some follow-up for what Dr. March just said.
Have I answered the question, sir?
I've got a follow-up question. I think you were teaching class respectfully. So let me ask you this. You're not here testifying that Unit 3 was the most efficient, most productive, and cleanest plant in the Evergy, Missouri fleet, are you?
That's a normative statement. I mean, when we sit there, well, what's the most efficient, and what's the most cleanest? I mean, compared to what?
The other units in its
And
fleet.
I responded that it wasn't.
Okay, all right. Let me ask you this. You compare Evergy, Missouri West Motor Company. There's not a regulatory commission that sets the capital structure or the return on equity for Ford Motor Company, correct?
That's correct.
Okay. And when Ford Motor Company wants to operate a plant or construct a plant, it doesn't have to come to a commission to obtain a certificate of convenience and necessity, correct?
That's correct.
And the prices that Ford charges for its products are not set by a regulatory commission.
That's correct.
Okay. Now, in your direct testimony, generally, you refer to the integrated resource planning process here at the commission, correct?
Yes, sir.
Okay. Is it true that utilities don't plan for anomalous extraordinary events, for example, like a winter storm Uri?
I'm not sure I would agree with that. Maybe even in the most general sense.
Okay. Well, would you agree with your colleague, Ms. Mantle, who testified that there is no way to plan for all extreme circumstances?
I would agree with that.
And it would likely be cost prohibitive for customers to pay for an infrastructure that would anticipate anomalous and extraordinary events, correct?
Yes.
Have you read the testimony of Sierra Club witness Debbie Glick?
Unfortunately, I haven't.
Okay. Are you familiar with it at all?
I'm familiar with it.
Okay. Let me just ask you a question at a high level. If you can't answer it, that's fine.
Sure.
She essentially has testified that she wants Evergy to start a process of retiring its other coal plants. Are you aware of that, sir?
Yes, I am.
Do you agree with her recommendation to retire Iatan 1, Lacine 1 and 2, and Jeffrey 3 before the end of their depreciable lives?
No.
Okay. Do you agree that a prudent electric utilities analysis of whether to retire a generating plant should include an assessment of the cost to replace its capacity?
Yes.
Now, you have a short reference to securitization, specifically Evergy, Missouri West securitization case on page 73 of your SIR rebuttal. Am I not correct that the securitization statute 393.1700 prohibits the commission from considering whether a public utility, an electric public utility, does or has filed or should have filed a securitization case when it is dealing with a general rate case like this proceeding?
Mr. Zorbers, give me a second just to see what I said.
Sure. It is at page 73, and I'm referring to your lines of testimony at line 4 through 7.
Okay, hold on.
And this is in your SIR rebuttal, if I didn't make that clear.
Got it. All right. May you please repeat the question?
Yeah, I mean, doesn't Section 393-1700 say the commission is not supposed to consider whether a utility could or should have filed a petition for securitization when it's dealing with issues in a general rate case?
I'm not familiar with exactly what the statute says. I think there may be some miscommunication as to what I was referring to in terms of the securitization in my testimony, though.
Okay. If you could go to page 58 of your rebuttal testimony.
I'm there.
Okay. Now, in your testimony here, you have incorporated portions of public counsel's filing in the AAO case number EC 2019-0200, correct?
Yes, sir.
And on lines 22 through 24 of page 58, you state that, quote, a decision had already been made to retire Sibley, correct?
That's what it says.
And you further state on line 24 through line 1 of page 59 that both SPP and the local labor union were notified of Sibley's retirement was certain, but Mr. Ives' testimony did not reflect that reality, correct?
That's what it says.
Okay. Well, you're adopting this as your testimony, correct?
Yes.
Okay. Now, on the previous page, on page 58, you quoted an email from Duane, D-U-A-N-E, Anstett, A-N-S-T-A-T-T, who was vice president of these generation operations, in an email that he wrote on October 2, 2018, correct?
Yes, sir.
And were you aware that there was a follow-up email on October 3, 2018, that dealt with the subject matter of the retirement of Sibley?
I know that there were a series of emails that I think were included into evidence earlier today. I remember reviewing them, but I did not include them the entirety in my testimony.
Okay. I've got a copy of some of those emails, and I'd like to have those marked. Judge, I believe it would be Exhibit 134. For the record, this was attached to the late Mr. Schallenberg's rebuttal on behalf of public counsel, and I'm citing these because Dr. Mark has cited some of Mr. Schallenberg's rebuttal as well.
No.
I think I have more
Yeah, there's more.
emails.
Sorry.
Dr. Mark, I've handed you what I've marked as Exhibit 134. It was attached to Mr. Schallenberg's rebuttal in the AAO case EC-2019-0200. It is marked Schedule in all capitals RES-S-1, Part 4, pages 1 through 15. Is that correct?
Yes, it is.
Okay. Now, sir, if you would go to page 4 of 15.
I'm there.
Okay. That is the October 2, 2018 email that you quote on page 58 of your rebuttal testimony.
Yes, it is.
Okay. Among the recipients of that email were, and I'm looking at the 2 line, on the second line below that, Darren Ives, correct?
Yes.
And then on the 3rd line, do you see the name Kevin Bryant?
Yes, I do.
And do you know who Mr. Bryant is?
Yes, I do.
Okay. Am I correct? He is the Executive Vice President and Chief Operating Officer of Evergy?
Yes, sir.
Okay.
Dr. Mark, could you please scoot a little closer to the mic? Sorry to interrupt. Please go ahead.
Okay. And then at the end of the 4th line, going on to the 5th line, is Terry Bassam, who at the time was the Chief Executive Officer of Evergy, correct?
That's correct.
And this email was sent at 1:53 p.m. on October 2, 2018, right?
Yes, sir.
Okay. Now, the next day, Mr. Bryant replied to Mr. Anstedt's email on October 3, 2018 at 2:57 p.m., correct?
Yes.
And at the bottom of that page, which is page 3 of 15, he thanks Mr. Anstedt and his team for their work. And then looking at the second sentence, he says, quote, "We will plan to review such recommendation at the CEO staff meeting on October 15 in advance of a comparable review with the Evergy board at the operations committee and full board meeting later this month." Is that correct?
That's correct.
Then the final sentence says, "Once we've reviewed with the board, we can then circle back with the management team to review any feedback received and make a final decision." Did I read that correctly?
Yes, you did.
Okay. So although Mr. Anstedt recommended that Evergy close Sibley on October 2nd, essentially on October 3rd, Mr. Bryant's saying, hold on, we're going to study this more and then we'll get back to you, correct?
That's what the email says.
Okay. And then the next email is above that, again on page 3 of 15. And Mr. Bryant, on Saturday, November 10, 2018, at 12:30 in the afternoon, says all, and this is directed to a number of people, and it states, "With feedback from recent management and board meetings, I'd like to recommend moving forward with plans to cease burning coal at Sibley," close quote. Did I read that correctly?
Yes.
And he essentially says to Mr. Anstedt and his team and others, if anybody has any concerns, they should let him know by the end of the day on Monday, November 12th. And absent that, he says we're going to move, we would like to begin, he says beginning, I think he means begin definitively moving forward on Tuesday, November 13th, correct?
Yes.
Okay. And do you have any reason to doubt this chronology, Dr. Mark?
No.
And then on the next page back, page 2 of 15, from Mr. Anstedt to Kevin Bryant, he says, "KB, thanks for the support here. Having heard nothing contrary, we will move forward accordingly starting tomorrow. Any concern with this direction, please just let us know," correct?
Correct.
Okay. And then the final email is Mr. Bryant saying, "Sounds good, DA," signed KB, meaning Mr. Bryant, correct?
Correct.
And that final okay was given by Mr. Bryant on November 13th, 2018 at 4:12 in the afternoon, right?
Yes.
Okay. Now, at the top of page 59, line 1, you state, and I'm quoting, "In fact, comma, Mr. Ives was expressly told one day prior to the on-the-record presentation that GMO was definitely going to retire the Sibley units and did not bring this up at the presentation," close quote. Did I read that correctly?
Yes.
Okay. Now, the presentation that you're talking about was in well, in what proceeding?
The last rate case.
Right, the 2018 race. Okay. And isn't it true that the final decision to retire Sibley had not been made on October 2 or October 3, 2018?
Based off of the email chain you read, it would appear so.
No further questions, Judge. Thank you. Oh, did I move the admission of Exhibit 134? I believe I did not.
No. So moved. Counsel, you have heard the motion by Mr. Zobrist. Any objections to the admission of Exhibit 134, which is a data request 1039?
Your Honor, I do object. Again, this is duplicative of the prior. The only difference is that they included DRs 1040 through some other at the end, which was not questioned on. Because they were not questioned on, I'd like to stand on the prior exhibit, which is the same.
Judge, this was offered in impeachment of this witness to clarify certain things. He cites in his rebuttal testimony a number of exhibits from Mr. Schallenberg. That's exhibits that bear the markings RES-1, and this was meant to clarify and further elaborate on the testimony of Dr. Mark.
I appreciate that, Mr. Zobrist. My question, and public counsel's question, is why did you include the data response for 1041, 1043, 1046, 1047, and 1052?
Because that's what Mr. Schallenberg in here, and I did not want to truncate or separate that and be subject to an objection that I wasn't presenting the entire thing. I would say, I guess, one further thing, it clarifies that the estimated amount of repairs was $2.21 million, Judge. I think I heard a different figure earlier in the case, and this relates to other discussions that we have had on the issue, so I felt that the integrity of the exhibit really required me to offer it in evidence as it was presented initially to the commission.
Okay, but you're pointing out of the accuracy of the number is in the emails.
Correct.
Okay. Here is the problem from my point of view is citation, because we now have two exhibits with different page numbers that say the same thing. And since nobody has brought up the extra data responses, and I think a party would be able to object if they felt that it was incomplete, I'll ask for any objections to Exhibit 134. You did make an objection. Is that correct?
To clarify, my objection is that it's duplicative.
Yeah.
It is literally already in the record. We don't need a second one.
So the answer is yes. OPC made an objection. Mr. Zobrist, did you have any further reply?
Well, I mean, Judge, I wanted this in here because this was a public counsel exhibit. This came in from Mr. Schallenberg in the AAO case, and I think I'm entitled to have this come in the way it came in because Dr. Mark cited some other things from Mr. Schallenberg. He didn't cite this. I think that goes to credibility and to other issues. This is not unduly cumulative under the administrative procedure rules. I mean, the things that are unduly repetitive and cumulative, this is, 15 pages. So I don't see that there's a burden, and I see that there's no prejudice, but I think it's helpful to place this in context, as well as some of the other additional information that I didn't particularly cover, but I think is relevant to a number of the discussions that we have had today.
Your Honor, if it'll help, the OPC will stipulate that these emails were included as an attachment to Mr. Schallenberg's testimony. There's no reason to have two versions of the same set of emails.
Mr. Zobrist, I would like to know your position on my problem with citation. At the end of the case, we're all writing briefs or orders, and you cite to Exhibit 134, page 2. And Mr. Kleiser cites to Exhibit 131, page 1, and it's the same quote. That's my problem.
Judge, I respectfully don't see that's a problem, but if you want us to have dual citations to make it clear to you and to the commissioners, I'd be glad to do that. But I think the fact that I've got at the bottom that this was a schedule that public counsel offered and it was not included in this manner by this witness, I think goes to his credibility, and I think it's important.
Could staff suggest that perhaps 134 stay in the record and 131 be removed? Then it's no longer duplicative, there's no longer the need for double citations. You know, if it seems like 134 is more pressing for Evergy to make its case than 131 was. That seems a simple solution.
Yes, work for us because that solves the duplicative problem. Can we strike all the DR responses at 1039 since they are not part of the cross-examination?
What I heard was a pretty forceful argument by Mr. Zobrist. I don't know what I'm missing because, Mr. Zobrist, your point is this is a minimal thing, which would lead me to my question, why not go with the first one? But you have made a passionate argument over what appears to me to be a smaller issue, but I'm not a lawyer in the case. I have a solution, and without objection, and I'm sorry, if there are no objections, I'm going to admit Mr. Zobrist's Exhibit 134. I'm going to Exhibit 131. Excellent. I heard no
objections.
So done. Exhibit 131 is stricken from the record. We will keep Exhibit 134.
Thank you, Judge.
Where are we at? We're on cross-examination.
Right.
Thank you. Go ahead.
No, I'm finished.
Okay. Who's next for cross-examination? And I think that is going to be the commissioners. Do any commissioners have any questions for Dr. Mark? Hearing none, the bench also has no questions. Redirect. Mr. Kleiser, go ahead.
All right, thank you. I can't seem to get close enough to this mic. All right, let's talk about some emails. Just to start off with, I want to make sure that it's clear. The whole section here that was being cited from your rebuttal testimony, that was an excerpt from the brief of the Office of Public Counsel filed in the complaint case.
That's correct.
And you were adopting it, correct?
That's correct.
Just want to make sure that was obvious. All right, now, with regard to the emails, how did they affect what you were attempting, or rather, Evergy was arguing that it was not certain that the plant was going to be shut down, right?
That's what they were arguing in the rate case. As that rate case was taking place, this information was never brought to our attention or to MECG's attention. We entered into, there was various stipulations and agreements that were entered into. Again, this information was never brought. We wrote copious amounts of testimony before this, raising this as an issue, wanting to try this as an issue. Again, skirting the line over settlement discussions or not, I think a reasonable person could say that their position may have been altered had they been aware of this information. And this is what drove us ultimately to file the complaint case with the commission.
And it's true that the decision to retire Sibley, at least by December, had been made long before the rate case.
The company had the opportunity to bring this information in front of the commission beforehand. They could have brought this information before rates went into effect. They chose not to. Again, this is why we brought the rate case, or we brought the complaint case And I should qualify that the complaint case as an AAO because PISA wouldn't allow us to go ahead and mess with base rates after the first of the year.
Do you fully agree with the assessment that the decision wasn't made until November to retire Sibley?
Personally, no.
Why?
Well, Judge, yeah, I think that does call for speculation unless there's something more to the question Mr. Kleiser wants to ask.
I would have to agree on its face. Mr. Kleiser, do you have a response?
I'll move on.
Thank you.
I might come back to that. Dr. Mark, you were asked about statements on page 73 of your SIR rebuttal. Do you recall that?
Yes.
Lines 4 through 7. And at the time, you were trying to explain what exactly you were referring to by that section in referencing securitization. Can you please explain what you were referring to?
I'd like to read it out loud, just so the court has a record of this, but it's, there is of course a legitimate argument for the commission to disallow fuel costs related to Evergy West's inability to properly manage its resource adequacy in the securitization case, and to disallow capital costs related to the Sibley stranded investment in this case. But I failed to see how management can be deemed to be prudent in both cases. What I was attempting to say before I got cut off was that my testimony wasn't implying to securitize Sibley in this case. I was referring to the securitization of Storm Uri cost.
You were asked questions regarding the IRP process and whether or not utilities plan for anomalous events. Do you recall that?
I do recall that.
Is your prudence argument based on Evergy's failure to plan for an anomalous event?
No, it's not. Mr. Zorber's, I think the phrases that he used were efficient and clean, I think were the two that I remember. What I would also point out is size matters. And 25% of your generation load matters if you're taking it off of your resource mix while you're increasing load simultaneously. That was the concern. That is still the concern today.
Were there other problems that you saw with regard to the IRP process regarding the decision to retire Sibley?
Many. The IRP process, I would first say, is that it's not a prudency process. There's very little recourse for us to go ahead and air our grievances other than to file memorandums saying as much, which we did, and that's included in my SIR rebuttal testimony. But the key thing that was significant about the IRP process is it looked at the modeling of shutting down Sibley within a vacuum. It did not take into account that if you see renewable prices going down and cheap, efficient electricity generation coming up with renewable, being able to take advantage of tax credits and so forth, in a vacuum, it would make sense to shut down that coal plant. But if you're seeing that, what is everybody else seeing? And everybody else in SPP market is responding the exact same way. And if that market is all acting in a certain way, which again, I point back to that Wednesday agenda meeting with SPP, then you've got problems. You have diminishing returns, first of all, in the amount of renewables that can come online, where you end up getting, SPP has to get creative, and you have to have performance-based renewable capacity accreditation, because each one of those incremental renewables is being valued at a lower level. It also means that the remaining baseload coal plants are that much more valuable. When I was crossed about Sierra Club and Sierra Club's points, I maintain, and I believe the company's position, it's the same too, that they can't just shut down Iatan and Jeffrey for that very reason. We won't have reliable power, but it cuts both ways.
There was a discussion about plants that were more efficient, less efficient, more dirty, less dirty. Do you recall that?
I do.
Just for the record, are there plants within Evergy's generation fleet that you consider to be less dirty, more dirty than Sibley?
Yes.
Or less efficient?
Yes.
And those plants were not shut down?
That's correct.
What is your understanding of why those plants were not shut down?
it would probably be speculative on my part to sit there and say why, certain plants were chosen over another beyond the fact that Sibley was wholly owned by the company. So they were in a
Judge,
position to
if
shut it
that's
down.
speculation, then I'm going to move to strike.
And you had mentioned at the time that OPC has raised other concerns regarding reliability.
Yes,
And have we seen those concerns play out?
we're seeing it play out right now.
In what ways?
Increased fuel costs, the exposure to anomalous events that may be more reoccurring. We see it being played out as the SPP's capacity requirements increase to account for that. All of these are going to be costs that are going to be borne by customers. And it's not enough just to consider it in the context of a generation as a whole. You also need to take into account the additional transmission and distribution investment that's going to be tied to that. All of those are real costs that are going to be borne by ratepayers.
Are you aware of any recent presentations that discuss these problems?
Object, that's vague and ambiguous. I'm not sure what that's referring to.
I'll waive. You were asked questions regarding shutting down Sibley and whether that provided an environmental benefit. Do you recall that?
Yes,
Were there certainly detriments to shutting down Sibley as well,
yes.
such as?
Increased exposure to the SPP market, increased fuel costs, increased, value of lost load in terms of reliability issues, increased cost associated with this whole endeavor that we're in right now in determining, what the appropriate depreciation value is and where it should be booked and how it's going to be recovered back from ratepayers. All of these are byproducts of that decision.
Were there any way that Evergy could have achieved same or similar environmental benefits without fully shutting down the Sibley facility?
Sure. Seasonal dispatch, even mothballing it, would have at least opened up that opportunity. There's a variety of different methods. It's not an option.
You were asked about other states having higher rates that have, I believe the term is deregulated. I'm not sure if that's accurate. Do you
Yes,
recall that?
I do.
Is that a fair comparison to this state or to the competitive market the questions were driven at?
Context is important as to why deregulated states, really, when we're talking about deregulated states, you're talking about, movement that took place and really primarily on the coast at the turn of the century. And it was really halted, due to, I would say, accounting issues stemming from Enron, stemmed the tide on deregulation across the United States. But the reason deregulated states tend to have, in general, higher rates than vertically integrated states to date has been in part because of a lot of merchant investor-owned generation that was prematurely retired too. So those were additional costs being borne by customers at that time. The most recent examples I've seen of comparing deregulated versus regulated states are at least a few years old. It was difficult to go ahead and draw for me to say one way or the other at this point.
You were asked about your statements regarding a perverse incentive to increase rate base. Do you recall that?
I do.
That concept of a perverse incentive, is that something unique to you, or have other people raised that similar concern?
The concept's also coined as the Average-Johnson effect, or gold plating. It's the preferred term of art in this field. But it basically implies that a utility has a perverse incentive to build rate base. I can say I've been in discussions with CEOs and executives that have said, quite frankly, my goal, I feel like my job is to go ahead and increase rate base. And as you increase rate base, that increases the opportunity for earnings. And that's not to suggest that OPC doesn't want a healthy utility or that OPC doesn't believe that investment is necessary. Of course investment's necessary. We try our damnedest to call balls and strikes when we feel like it moves outside of those lanes. In shutting down a coal plant that has as much generation that it was supposed to, capacity that was supposed to provide for its customers is an example of that. Add on the fact that it was 20 years prior to its end of its useful life. That's, from my vantage point, well within the scope of a prudency review. That's what a reasonable person would call a strike on.
So to the extent that there might exist that perverse incentive, what would you advise the commission to do?
Objection, Judge, that goes beyond the scope of my cross-examination.
I would disagree with that. I believe he was asked a question whether or not there was a statutory problem regarding a perverse incentive, and I would like Dr. Mark to explain why that's not the case.
Well, respectfully, that wasn't the question. The question was, what advice would you give the commission? So if he rephrases the question, I'd be glad to listen to it and decide whether to object.
In that case, let me rephrase the question. Do you perceive that there's a statutory problem regarding a perverse incentive?
I think it's incumbent upon the commission to be cognizant of when utilities increase rate base unnecessarily. And I think it's our statutory directive to make the commission aware of that when we feel like that's the case.
And you were asked a question at the very beginning of cross-examination by Evergy, whether or not only prudently incurred costs are passed on. Do you recall that?
I do.
So to summarize, your position in this case is that the retirement assembly was not a prudently incurred cost.
That is correct.
Thank you, Your Honor. No further questions.
Thank you. You are excused, Dr. Mark.
Thank you.
Let's go ahead and call up Mr. Robinette. And Mr. Robinette, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. Mr. Kleiser, your witness.
Let's see if I can do it right this time. Mr. Robinette, can you state and spell your full name for the record?
John A. Robinette, and Robinette is spelled Robinett.
And by whom are you employed and in what capacity?
I'm employed by the Missouri Office of the Public Counsel as a utility engineering specialist.
And did you prepare or cause to be prepared testimony which has been pre-marked 309 for the direct testimony, both public and confidential, 310 for the rebuttal testimony, both public and confidential, and 311 for the surrebuttal testimony?
Yes.
And if I were to ask you the same questions that were posed in those testimonies today, would your answers today be the same or substantially similar?
Yes, they would.
And do you have any corrections to make?
None at this time.
And are the answers to those questions true and correct to the best of your knowledge and belief?
They are.
All right, Your Honor, I would offer Exhibits 309, the direct testimony of John A. Robinette, public and confidential, 310, the rebuttal testimony of John Robinette, public and confidential, and 311, the surrebuttal testimony of John Robinette.
Thank you, counsel. You have heard the motion. I will combine them, as is my practice. Are there any objections to the admission on the record of Exhibit 309, 310, and 311, both the public and confidential versions respectively? Hearing none, so admitted. Go ahead.
I tender the witness for cross-examination.
Thank you. And again, for our future court reporter, we will call through the parties with some economy since some parties are excused. Charge Point, Google. No questions, Your Honor. Nucor.
No questions, Judge.
City of St. Joseph, Dogwood, Sierra Club, Renew Missouri,
No questions, Your Honor.
Missouri Industrial Energy Consumers, and Mr. Opitz for MECG.
No, thank you, Your Honor.
Staff,
No questions, thank you.
Velvet Tech,
No questions, Your Honor.
and Evergy.
No, thank you.
Are there any commissioner questions for Mr. Robinette? It's star 6 to unmute if you're on the phone. Hearing none, the bench does have a couple questions. In the complaint case we've been referring, EC-2019-0200, Mr. Spanos included an updated accumulated depreciation reserve for Sibley. Are you familiar with his testimony and methodology for how he got to the $145.6 million net book value?
I would say generally, but I don't know. I haven't reviewed it all specifically.
What is your opinion on that methodology?
That methodology looks at a very specific set of time, and what it does is it goes back and looks at all of the vintages and tries to calculate out what reserves should have been if a certain rate had been in effect for the life of that asset. And then that's all summed up to get to that value.
And you, your calculations for the proposed value, are those calculations included in your testimony? And work papers are not included in what is filed with the commission.
I understand that. I'm trying to think. I believe I walk through the math in my testimony. Specifically, my rebuttal beginning at page 16, line 9.
Okay, thank you. That's all the questions from the bench. That does require you to stay there, and we will go to recross. Again, for our future court reporter, we're going to go through those excused parties rather quickly. Charge Point, Google. No questions, Your Honor. Nucor.
No questions, Judge.
City of St. Joseph, Dogwood, Sierra Club, Renew Missouri,
No questions, Your Honor.
MEC, Mr. Opitz with MECG,
No, thank you, Your Honor.
staff,
No, thank you.
Velvet Tech,
No questions, Your Honor.
and Evergy.
No, thank you.
Redirect.
Yep, should be brief. I'm hoping so. Mr. Robinette, you were asked a bench question regarding your calculations included in testimony. You recall that?
Yes.
Did you stake a specific position as to what the remaining net book value of the Sibley asset is in your testimony?
So I went through two different scenarios to arrive at a final total that also included the dismantlement costs. Yes.
And why did you do two?
I've got to go back through my testimony and review it.
Ms. Robinette, if you think your testimony will explain it yourself, we can move on.
I think it will.
Never mind then. Let's move on. You were asked your opinion on what Mr. Spanos, the theoretical calculation Mr. Spanos performed in the complaint case. Do you recall that?
Yes.
Does what Mr. Spanos did, as you described it, consider what has actually been collected for depreciation reserve?
I struggle to answer that question only because it considers the entirety of what has been collected among all of those assets. And then he determined how to allocate that based on a theoretical position.
And do you see a problem with that?
I don't know that I would do a theoretical reserve calculation for that starting point of what was unrecovered. I would have relied on something else.
No further questions. Thank you.
Mr. Robinette, you are excused. Thank you, sir.
Thank you.
Sorry.
Your Honor, I have a question about an examiner from earlier. I think it was the rebuttal testimony of John Spanos from the 0200 case.
Exhibit 133.
That's 133, and that has been admitted. Is that correct?
Yes.
And so we're done with Spanos, or?
No, we are, as soon as we are done with Mr. Meyer, my intent is to ask if any counsel has questions for Mr. Spanos.
Okay.
Okay.
Thank you.
Mr. Meyer, please, I'm sorry. I startled you a little bit. Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please have a seat. And Mr. Opitz, your witness.
Mr. Meyer, can you state your name for the record?
Greg Meyer, M-E-Y-E-R.
And where are you employed and what's your position?
I'm employed by Brubaker and Associates, Inc., and I'm a principal.
And did you prepare on behalf of MECG direct testimony, public and confidential versions, exhibit number 400, rebuttal testimony number 401, and surrebuttal testimony, public and confidential versions number 402 in this case?
Yes, I did.
And do you have any corrections to make to that testimony?
No, I do not.
If I were to ask you the questions posed in that testimony, would your answers be the same?
Yes, they would.
And the answers in there are true and correct to the best of your knowledge?
Yes, they are.
Your Honor, at this time, I'd offer exhibits 400, public and confidential, 401, and 402, public and confidential, into the record, and tender Mr. Meyer for cross.
Thank you. You have heard the motion restated by Mr. Opitz. Are there any objections to the admission of Exhibits 400, 401, or 402? Hearing none, so admitted. The witness has been tendered. Again, for our future court reporter, we will go through all of the names with some economy. Charge point. Google.
No questions, Your Honor.
Nucor.
No questions, Judge.
City of St. Joseph. Dogwood. Sierra Club. Renew Missouri.
No questions, Your Honor.
Missouri and MIEC. Mr. Kleiser with OPC.
Thank you, Your Honor. Good afternoon, Mr. Meyer.
Afternoon.
Were you present earlier when Mr. Spanos was testifying?
Yes, I was.
I believe Mr. Spanos suggested that he disagreed with the description of what he performed in the 2018 complaint case as a theoretical calculation. Do you recall that?
I believe I do.
Do you agree that what was performed in the 2018 complaint case was not theoretical?
In the 2018 case?
Complaint case, sorry.
On the complaint case. Mr. Spanos' testimony says that his calculation is based off of a theoretical reserve.
To clarify the record, it was the 2019 complaint case. That's my fault. Sorry. I know that your position disagrees with what the starting net book value is, but you would agree that the theoretical calculation performed by Mr. Spanos at least properly considers what has already been collected, right?
No, not whatsoever.
Would you agree with me that the application of the theoretical reserve calculation performed by Mr. Spanos in the complaint case is consistent with his approach in the past?
No. In fact, Mr. Spanos provides testimony that says you should not use the theoretical reserve to establish depreciation rates.
Would you agree with me that Mr. Spanos established a depreciation rates in 2016?
I believe he did a study, but those rates weren't approved by, were not used to set rates for averaging. The last time depreciation rates were used or were approved is in a 2010 case. And I can track those rates all the way up through this current rate case. This is the first rate case they've changed since 2010.
Do you have a copy of the rebuttal testimony filed by Mr. Keith Majors?
No, just this is direct and sir rebuttal.
That's all right. I'm going to read you a passage from his testimony and ask if you agree with what Mr. Majors is testifying. Starting on page 4 at line 19, Mr. Majors states, Evergy West witness Kennedy used the same 145.6 million NBV as calculated in the AAO case by Evergy witness John J. Spanos. Do you agree with that statement?
Evergy West used 145.6 as an NBV as calculated by Mr. Spanos in the 2019 complaint case. That's correct.
Mr. Majors goes on. His sponsored NBV is not related to the amount that was included in the cost of service for the Sibley plant in case number 28, in the case number 2018 rate case, and is based on a, quote, theoretical reserve, end quote, calculation. Would you agree with that?
That's absolutely true.
Mr. Majors goes on to say, although Mr. Spanos briefly explains the method of calculating this amount, there is no clear reasoning why this method is superior to the allocated reserve amount included in the 2018 rate case.
Would you agree with that statement?
I would agree that the use of a theoretical reserve calculation to come up with a net book value for Sibley was inappropriate.
Continuing on, Mr. Major says, this amount was $300 million and formed the basis of the depreciation expense and rate of return calculation, which was ultimately included in the cost of service in the 2018 rate case. Would you agree with Mr. Majors on that statement?
Yes, the 300 million can be traced to not only the accounting schedules, but to the accompanying work papers that were provided for the true-up. So both the company and the staff agreed that the net book value of Sibley was $300 million, according to their true-up calculations, which was the basis for at least negotiating the rate case.
Are you familiar with the report and order that was filed in the complaint case?
Yes.
Is your recommendation in this case premised on the assumption that the commission ordered the company to track return on based on the amounts from the 2018 rate case?
The commission ordered that parties should calculate the regulatory liability, which includes the return on of the net book value of Sibley and the O&M and what was included in customer rates.
Returning to Mr. Major's testimony, again at page 5, line 8, he states, I can conclude that the NBV of $300 million is the amount upon which the AAO, quote, return on, end quote, deferrals should be calculated, as that amount was the basis of the rate of return and depreciation calculations. Is that consistent with your position?
Yes, and I think Mr. Majors earlier today said that if the commission adopted my position, his calculation would be the same.
So based on at least this rebuttal testimony, you would believe that staff is agreeing with your position?
Well, that testimony, yes, I think Mr. Majors, in all due fairness, highlighted his position on the witness stand, and he's back to 145, which I disagree with.
I have no further questions. Thank you, Your Honor.
Thank you, Mr. Kleiser. We will turn to staff, and I will gently remind our witness, Mr. Meyer, please move that microphone as close as you can. It's for our future court reporter who will have to transcribe this. Staff, counsel, please go ahead.
Nicole Mers for staff. Good afternoon, Mr. Meyer.
Afternoon.
Are you familiar with the company's argument that because the decision to retire Sibley was prudent, disallowing the return on the plant subverts regulatory principles?
Yes, I'm familiar that they're arguing for a return on a retired plant.
Are you aware of any expenses incurred by the company that are not recoverable in rates but are not disallowed due to prudency?
Can you repeat that, please?
Sure. Are you aware of any expenses or costs that are incurred by the company that are not recoverable or used to set rates or included in rate base, but they are not disallowed or not included in rate base because of a prudency determination?
Yes.
And would an example of that be rate case expense?
Well, I mean, there's several examples. Anytime you normalize a test year expense or amortize it over several periods of time, those are instances where the exact cost of providing service and the rates don't sync up. There's also disallowances, typically on dues and donations that the staff makes, that, the company continues to do those, knowing the regulatory treatment, so.
And for an example, again, I'll focus on rate case expense. Are you familiar with the justification that the parties have used for sharing cost?
Right. Rate case expense has typically been 50-50 between customers and I'll call them shareholders. So that would be an expense that, you know, there's been no argument about whether those would cost. Well, there have been arguments. I take that back. I believe in a prior KCPL case or Evergy case, there was an argument that the level of expenses, and I think this is what prompted the sharing, that the level of rate case expenses was excessive.
And would you agree that the justification behind these examples, such as rate case expense, such as dues and donations, that sharing could be applied to allowing the return of but not on in this case?
Oh, absolutely. I think that allowing the investors the return of the investment, but denying the return on is a fair balance between shareholders and customers. I would also note that in many utilities, in their risk assessments that they put in their 10Ks, they list that possibility, that risk, that there will not be a return on power plants that are being retired. So they recognize it, and that's built in my mind, that's built into the ROE as a risk that's done and included.
You used to be a member of staff, is that correct?
Yes.
In your experience as a member of staff, and perhaps you've brought this practice into your consultant work, do witnesses constantly get new information and evaluate that information to see how that could update, change, or impact a position that has been filed in a case?
Well, I think that's the benefit of the rounds of testimony is that a witness can present a position in direct, and then depending on the response, they can update their position to either affirmatively say that it continues or that says, given some new information, a change in position is warranted.
And did you hear, or were you here for Mr. Major's testimony that was his process in developing his direct and rebuttal in this case?
I heard that. I don't agree with him, but that's okay.
Okay. And although you were asked about that 300 million number, is in staff's rebuttal, the 145.6, staff's position that has been baked in to their revenue requirement in the case.
Are you suggesting that the 145 is in rates?
Not in, I apologize, that was a terribly worded question. We'll just say it the easy way. Is staff's position in rebuttal the 145.6 the same as it was in direct for the net book value of Sibley?
Yes.
Okay, thank you. I have nothing further.
Thank you. That'll take us to Velvet Tech
No questions, Your Honor.
and Evergy.
No, thank you.
Okay, we will ask for commissioner questions. Are there any commissioner questions for Mr. Meyer? Hearing none, the bench does have a couple quick questions. These are going to be the same questions I had just asked Mr. Robinette. Are you familiar with the methodology that Mr. Spanos used to come up with the 145.6 million NBV, which is net book value for Sibley?
Yes, according to his testimony, it's based off of a theoretical reserve calculation. A theoretical reserve calculation takes the plant by vintage year and applies a formula to it. So it's 1 minus the net salvage value times the the original cost of the investment that's put in that vintage times 1 minus the net salvage times 1 minus the remaining life of the asset over the average life of the asset. So it doesn't, it's a calculation at a snapshot in time. It doesn't trace it doesn't attempt to trace any collection of depreciation expense on any asset. It just says this is, and it's used as a checkpoint, and Mr. Spanos in other testimonies has said, this is what it's needed for. It's just as a check. And so it's not, it has no basis and and in fact, in other cases, Gannett Fleming has testified that you shouldn't use the theoretical reserve to calculate depreciation rates. And I understand that. And the reason that is because if the theoretical reserve results in a calculation that exceeds the actual depreciation reserve, then the utility will be deprived of depreciation expense for that difference. And so it's a snapshot. It assumes that all the prior depreciation expense was adequate, and here's where the depreciation reserve should be. But it doesn't look at what was actually collected in rates, and that's one of the shortfalls, and that's why it shouldn't be used. So if Mr. Spanos testifies that you shouldn't use the theoretical reserve calculation to establish depreciation rates, then why should you use it to establish the value of an undepreciated asset for purpose of this rate case? I just can't get those two to connect.
Your testimony, did it propose a value of the net book value of Sibley, 300 million?
Yes, that was, and that's, just so we're clear, that's based off of the staff's EMS run, which we took Mr. Majors through the specific lines. And it's also based off of, and that's attached to my testimony, it's also based off the company's work papers that were provided to the parties that I think they identically match. I think Mr. Robinette has a slight difference. He says there's $2 difference in plant and $1 difference in reserve, but they match up exactly, and so does the depreciation expense. So there's unequivocal evidence that it's 300 million, and that's consistent with the commission order that said calculate this reg liability on what's being collected in rates, and what ratepayers are being asked to pay in that case was a recovery of $300 million of net book value.
Okay, that is all the questions I have. I'm sorry, Mr. Meyer, I'm going to ask you to stay on our witness stand just a little longer. That takes us to recross. Again, we will go through the parties. Charge point. Google.
No questions, Your Honor.
Nucor.
No questions, Judge.
City of St. Joseph. Dogwood. Sierra Club. Renew, Missouri.
No questions, Your Honor.
MIEC. OPC and Mr. Kleiser.
No questions, thank you.
Staff. No questions, thank you. Velvet Tech.
No questions, Your Honor.
Evergy.
No, thank you.
Mr. Meyer, you are excused. Thank you, sir.
Your Honor, I might have some redirect.
I'm not leaving yet.
Please stick around, Mr. Meyer. Presiding officer is mistaken. We do have some redirect. Please go ahead.
Mr. Meyer, OPC was asking about he was asking about the report and order in the complaint case, saying that you should calculate the regulatory liability according to rates. Do you recall that?
I do.
And why is it important that why is that important to your testimony in this case, that is what the commission order talked about?
Well, there's two ramifications for changing what's in the commission's I'm sorry. There's two ramifications from changing what was presented in the company's work papers and in the staff's EMS. The first one is that you are assigning, if you use the 145, you're not capturing the full undepreciated or unrecovered undepreciated value of Sibley. That has two impacts. The first one is if you use the 145, you're understating the return on the regulatory liability that would be calculated, and you're also understating the amount of investment that should be not subject to a return on the investment as proposed and supported by the staff, OPC, and MECG. So there's two distinct ramifications by not going what's in the EMS run or the company work papers. And these both affect what ratepayers paid. It's unquestionable that ratepayers were paying for a net book value of $300 million. We've established that in both the company's work papers and the staff's. And yet, when you want to move to a lesser value, you're taking money away from customers that have paid into that and not allowing them to get a refund for that, and then also requiring them to pay a return on a portion of that plant going forward.
Staff was asking you about Major's process, witness Major's process for, I guess, changing his position in this case. Do you recall that?
I do.
And she listed, I guess, the direct 145, and said that was the same in surrebuttal. But he also had a couple other positions. Well, let's just say you recall her talking about that. So she listed those, and are you also aware of other positions he might have taken in this case?
Well, two things. He agreed with us, or agreed in cross, I'm sorry, that $300 million is the unrecovered investment in the accounting schedules. He also agreed that there is no place where he can point to where rates are established under the 145 that he supports or the staff supports. So I still have struggled this whole time that given the commission order that says what's collected in rates, how the 145 can be adopted, because it's never, and Mr. Majors correctly said this, it's never been put into a rate calculation.
And on the stand today, he also talked about a 234 number.
Right.
And that was his attempt to try and calculate using old rates. You remember that?
I do.
And he essentially seemed to say on the stand that while he did that, it was kind of a high-level evaluation, and he wasn't sure about it, so he was defaulting to keeping at the 145. Is that your understanding?
Judge, I'm sorry, this is beyond the scope of bench questions and cross.
Your Honor, I guess staff was asking about the process to which staff came to, at least in my view, go from one position to another and then back to another in surrebuttal. And I'm asking about, I guess, the additional developments in that process and I guess Mr. Myers' view of how that was done.
I'll allow it.
Okay. Mr. Myers, what's your view of how that calculation was done?
Well, I haven't had the opportunity to review Mr. Major's 234 calculation. However, his 2/3 argument, I believe, is significantly flawed if you look at the work papers that were supplied by Mr. Spanos in the complaint case, approximately $190 million of new plant investment is invested in the Sibley units from 2007 forward. So the idea that you know, that the depreciation reserve could be, you know, isn't meeting the 2/3, that has a direct impact on the low value of the depreciation reserve. There's been a significant amount of money spent at Sibley since 2007, and I think that could address the $300 million that we have now too. And the reason that is, just to follow up, if you have investment of that magnitude, $190 million over the 476, just to give you a feel, it's not had the opportunity to be depreciated like a piece of property that was put in 2000. Plus the fact that depreciation rates until this rate case haven't changed since 2010.
Going back to a question Counsel for OPC was asking you, essentially he asked whether there was any clear reasoning why he was quoting testimony, I believe, and he was saying there's no clear reason why one method to use determine depreciation is superior. Do you recall that?
I do.
And in your view, which method is superior and should be used?
Well, to calculate the depreciation expenses, it's imperative, and I think Mr. Spanos would agree with me, that you have to look at the reserves that have been collected and not the theoretical reserves. And in Mr. Spanos' work papers, again provided in the complaint case, he identifies through the 5 major steam production plant accounts approximately $599 million of theoretical reserve. The total allocated reserve, or the collected reserve from that, is about $411 million. And that's why Mr. Spanos strongly urges people to not use the theoretical reserve to set depreciation rates. Because if you'd done it in this case, using the theoretical reserve, you would have recognized $189 million, $190 million of depreciation reserves that weren't collected from ratepayers. And that would have lowered significantly the depreciation rates that Evergy would be allowed to collect on a remaining life basis. So I agree with Mr. Spanos that I don't think you should use the theoretical reserve to determine depreciation rates. But I do believe that it's also imperative that you don't use it to calculate a reserve that was clearly marked in work papers from the company and the EMS runs from the staff.
So the reserves that should be used in this case, which ones are those?
300 million, the 300 million unrecovered at June 2018, updated through the rate effective period in this rate case.
And using that value of reserves ensures that customers aren't paying a return on this retired plant, correct?
They're not paying a return on this retired plant, and they're also being fully recognized for the money they paid from the date it was retired until the new rates are effective in this case. So it's twofold.
And that's a just and reasonable outcome, in your opinion?
I wouldn't have proposed it if I didn't think it was.
I don't have any further questions, Your Honor.
Thank you, Mr. Opitz. Mr. Meyer, you are excused. We are at the end of the day, and as promised, we are going to see if Mr. Spanos is available. First, before we call him up, I will ask if any parties have questions for Mr. Spanos.
No.
Anybody that has a question for Mr. Spanos going once? You do? Oh, I'm sorry. Keep discussing. Go ahead. Oh, no, you're fine. Let's go ahead and call Mr. Spanos up to the stand.
Your Honor, I would ask that at this point, if we're doing recross of Mr. Spanos, this is Tim Opitz speaking for the record, that it be limited to the new exhibits that were offered after he was on the stand earlier.
OPC would second that. That was the purpose of asking for the additional cross.
That sounds reasonable to me, Ms. Mers. Okay. Yes, Mr. Spanos, please come up for the purpose only of responding to the exhibits that have appeared since your testimony. Sir, you may go ahead and have a seat. You've already been sworn in. I just remind you gently that still applies. Please talk slowly. Please use the microphone. Go ahead. Yes.
Nicole Mars for staff. In your testimony in the EC 2019-0200 case, you used theoretical reserve. Is that correct?
I think it needs to be clarified that I'm using an actual book reserve that has been assigned and developed based on all rates that have been in place. The assignment of the actual book reserve to the location level is based on the recovery and ages of those assets. And when you take that from the location level to the vintage level, the only way to calculate that is based on theoretically assigning that to the vintage level based on the age of the dollars. So in my testimony where I referenced that I have a theoretical calculation, I agree with Mr. Meyer, that was probably the only thing I agreed with him on, is that that should not be the basis. But it should be a basis of how you assign it to the vintage level based on the ages of the asset. The amounts by vintage or by location were developed based on the actual amount of accumulated depreciation that had been incurred through rates for the, in this case, all the steam assets themselves.
And you're employed by Gannett Fleming, is that correct?
Yes, I am.
And does Gannett Fleming provide teaching or educational materials upon depreciation?
We do train quite a few. There's the Society of Depreciation Professionals, which we offer a lot of training. We also do special training for utilities, commissioned staffs, and even some other interveners.
May I approach? Apologies, I do not have enough copies, but I have showed this to council.
Your Honor, I think I need to inquire if this exhibit is inside of that Exhibit 133 or related to that rebuttal, from that rebuttal testimony in the 0200 case? Because if it's not, I'm going to object to it as being outside the scope.
It is not in the rebuttal testimony, but it relates to the justification on why that method would have been used to, or at least I'm going to inquire, I do not want to assume, but the purpose of presenting it would be to inquire of the witness if he agrees with those reasons, and if those reasons were the basis for why he used that approach in the rebuttal testimony that is now an exhibit.
I'm also like to object on the basis that that questioning could have been brought forward at the prior cross-examination.
I'm going to allow it because we have
traveled quite a bit since Mr. Spanos was up this morning, and I would like to make sure that he has the opportunity to address some of our discussions.
So you kind of got the preview of where I was going, but do you see, and again, apologies parties that I don't have more copies of this, but the common uses on why theoretical reserve would be used, and could you read those aloud?
Yes, I do see that document. So the area to read theoretical reserve common uses. Used as the basis to allocate a functional plant book reserve to the plant account level for companies that do not maintain the book reserve at the account or sub-account level. Used as a basis to allocate a plant account book reserve balance to the vintage level. And used as a benchmark to assess the adequacy of the company's book reserve.
And would any of those reasons support why you use the theoretical reserve method as part of your rebuttal testimony in the complaint case?
Yes, all three of them are applicable. I think the key one that I was trying to explain in the first question you asked is we have the book reserve, how it's been developed at the account level, and it now needs to be assigned because we used to be at whole life and we did not have lifespan. So now when you add the remaining life and lifespan, you have to now assign the book reserve that has been calculated based on rates that were in place to that degree of detail at a location level and at a vintage level. And so it is used, the theoretical reserve is then takes that number that you have, and in this case, I'll say Sibley at 145, and assign that to the vintage level based on those recovery patterns. So it's allocating to the vintage level each of those assets.
Then your use of that method in your rebuttal testimony is not divergent than what is commonly accepted in depreciation studies or testimony. Is that correct based on that being training material?
That's absolutely correct, and that's the same process that I used in the subsequent, or the prior studies, the accounting order, and in this current study, all those same methodologies when you bring in lifespan and remaining life and how you calculate it at a vintage level. I did not change the total book reserve that had been recorded at the account level.
Okay, thank you. I have no further questions.
I am going to open it back up. We are way off book, so I'm just going to open it. I will come back to the company for redirect. You'll have the final questions. Are there any parties that would like to ask further questions?
I would, Your Honor.
Mr.
Tim
Opitz.
Opitz from
Yes.
MECG. Mr. Spanos, you were talking about, just a minute ago, theoretical reserve. Would you agree that the theoretical reserve is an estimate of the accumulated depreciation based on the current plant balances and depreciation parameters, service life, and net salvage estimates at a specific point in time? Put another way, it is theoretically what the reserve would have been had the current plant balances utilized the same depreciation parameters since the initial assets were placed in service.
I agree with what you read, and if that was the case, then the net book value for Sibley would be 0 because it's been retired. So that's why I do not agree with the fact that the way that is being portrayed here is accurate with that calculation, because if we use the parameters that were in place as of the retirement date, we would have gotten full recovery of that, including the net salvage component. So I think putting it into perspective as to what your question was, that's the appropriate answer.
Mr. Spanos, you testify on behalf of other utilities in the state of Missouri, is that right?
Yes, I do.
And what I read you, did that sound familiar to you?
The language that you read is familiar. I think, again, you need to understand the scenario that we're in this particular case and what's happened in the history of Evergy assets.
Well, that quote and opinion is from your rebuttal testimony in a recent Ameren, Missouri rate case.
Yes, and I think if you were to look at the Ameren rate case and the details of that case, those have unit breakdowns. I continue to use the actual book reserve in those cases
Your Honor.
for the account, and I lay it out in the same exact way I've done here.
Your Honor, there's no question pending. Would you agree, Mr. Spanos, that a theoretical reserve imbalance is merely a comparison of the book reserve to the theoretical reserve at a single point in time based on the service life and net salvage estimates? These estimates can and will evolve over time as more information is available.
They will evolve over time, and that is how you develop a remaining life rate. So the rates that have been approved take that into consideration in these calculations.
Would you agree that you've testified that theoretical reserve can provide a benchmark of a company's reserve position, but it is not the, quote, correct, end quote, reserve amount? The theoretical reserve will change every time a study is performed. For example, if there is a change in the estimated retirement date for a power plant, this will change the calculated theoretical reserve.
I agree with those statements and agree that that's exactly what's been done here. I have not assigned a theoretical reserve to each unit. I've taken the actual book reserve and assigned the amount that would be calculated based on the past rates and the parameters that are in place today.
And that's not, that amount is not tied to anything that was set in rates in the last Evergy rate case. Is that right?
Sorry, could you repeat that
Your
question?
theoretical reserve amount is not tied to anything that was established in rates in that Evergy rate case, the most recent Evergy rate case.
Can you explain to me what theoretical reserve you're asking about?
The 145 million you've calculated.
Again, as I've stated, I'm using the actual book reserve, and the actual book reserve is only assigned to the vintage level based on the theoretical
Spanos,
reserve.
that's a yes or no. Is that 145 included anywhere in the rates of the most recent Evergy West rate case?
The 145 was part of the calculation. It is not a theoretical reserve calculation.
Was that 145, however you want to characterize your calculation, included in the rates that were set in Evergy West's most recent rate case? Yes or no?
Can you give me what rate case you're,
The ER-2018-0146.
as I answered your question earlier today, the rates were developed under those methodologies with the changes that were required part of that case.
Those are your depreciation rates. I'm asking about, is this 145 included in the rates that were set in that ER-2018-0146 rate case? Yes or no?
Are you asking about depreciation rates, or are you asking about some other rates?
Can you point to anywhere in that rate case where that 145 amount was used to establish the rates?
The rates for, sorry, you need to help me, I'm not following.
Establish the rates customers pay. Can you point to anywhere where that 145 was relied upon in the ER-2018-0146, where that 145 amount you've calculated in this case was used to set rates in that case, paid customers.
Depreciation rates are a component of a rate case. That's as far as I can tell you. I don't know the specifics that you're asking me.
Is that a yes or is that a no?
Okay, Judge, this is beyond argumentative at this point and asked and answered multiple times.
Your Honor, I guess I'd ask you to, I don't think it's unreasonable to ask this witness to answer that yes or no if he can point to anywhere where it's in there. And I would ask you direct him to answer yes or no.
Evergy is going to have the opportunity to ask you to explain or expand on your answer here. As I understand the basic question, though, is can Mr. Spanos point to 145.6 million at any point in time before this case? Specifically, can he point to that number somewhere in the previous rate case?
I would also point out that Mr. Spanos is not responsible for accounting schedules. He's a depreciation expert. So.
And I would point out that we all seem to have agreed that the 145 looks to be new here, or not new, but it's calculated in this case. No? Okay. Mr. Spanos, can you give a yes or no?
I don't know the answer to the question that he's asking.
And I think I can help because he's talking about rates, but the customer rates that they pay for electric usage, not depreciation rates. I think we're getting very confused on using just the abbreviated rates. Try your question again.
Can you point me to anywhere in the most recent Evergy West rate case, ER-2018-0146, that would indicate customer rates for usage were based upon your amount of $145 million?
For the record, same objections.
I'm going to allow it because I know the answer I expect, and I have not heard that. Go ahead.
Are you asking me to answer that question yes or no, or could I give an answer to what I understand?
I'm asking for a yes or no.
Let's.
Judge, I would ask that he be allowed to fully answer the question if he's going to be put to it.
They'll have an opportunity to redirect and say.
This is a settled case that we're referring to. He doesn't.
I don't see the difference in allowing Mr. Spanos to explain following a yes or no, and the difference between allowing his counsel to ask him on the promised redirect. So, Mr. Spanos, if you can start, please, with a yes or no, I would be very interested in hearing your explanation. But I would like, for the record, to get Mr. Opit's question answered, beginning with a yes or no.
I'm sorry, is he required to answer yes or no, or can he testify that he doesn't know or can't answer yes or no?
Oh, yeah, oh,
Okay,
absolutely.
thank
Oh, I'm
you.
sorry. Yes, those are options too. I apologize.
Yeah, I don't know the answer to how that is. I've calculated the 145 here and in the accounting order. Those are the times that I've calculated that number. It's been built on time. Before that, I don't know how that gets applied to customer rates as being asked in this question.
Were you retained by Evergy in that case? In the 2018 case, ER 2018-0146?
I don't remember the actual cases. They all kind of were together, so I'm sorry, I don't have the actual cases in front of me.
Do you have do you attach a copy of your case experience to your testimony in most cases?
I do.
And do you attach that to your direct testimony?
I do.
Can you turn to your direct testimony? And I'm trying to get there myself. Do you see anywhere in your testimony that refreshes your recollection whether or not you were retained by Evergy in that 2018 rate case?
During that time period, I do not see that. I see the EC 2019-0200 case as the one that I have listed on my list of cases.
So you were not a witness in that 2018 rate case?
No, I was part of the 16 case and the 19 work. I do not see any reference to writing testimony in that particular case. That list in my direct is when I write testimony or am orally giving testimony.
Okay. I have no further cross, Your Honor.
Are there any other questions for Mr. Spanos? Redirect.
Very briefly, that question that you were trying to provide a fulsome response to, Mr. Opitz, about rates in the 2018 case, could you please complete your response?
Sure. There's a lot of components that go into a rate case, and my conducting a depreciation study is one piece of that. And those results get applied to what's part of the rate case. And so I don't always know how that gets translated, whether it be a settlement or whether the actual ruling gets translated into each particular account as to what is utilized as the rates that was the depreciation rates as part of the rate case rates to customers. And that's why I was struggling with that answer, is because I don't get involved in that aspect of it. I'm working on developing depreciation rates for recovery of investment.
Thank you. No further questions.
Thank you, Mr. Spanos. You are excused.
Thank you.
Please be safe on your travels home.
Thank you. Appreciate you having me.
We will wrap up for today.
Your Honor, one request, I'm sorry.
Yes.
Stephanie Bell with Velvet. I would like to offer Exhibit 800 and ask that the commission take notice of it. It is the second amended report in order in file number ER-2022-0061.
I know the judge that wrote that.
I'll take one.
Okay, Exhibit 800, the very well-written second amended report in order. Are there any objections to its admission onto the hearing record as Exhibit 800?
Not sure if there is an objection, but I would like to understand its purpose. I don't know if it's relevant.
Your Honor, Velvet Tech doesn't have a witness in this case, and as you know, isn't currently taking service, but this case describes Velvet's position in relation to this case and status as a potential customer. And so I would like it entered.
That immediately brings up a question. As a potential customer, how come you just don't talk to Evergy? I don't hear any objections. So admitted.
Thank you, Your Honor. And then with that, I would request to be excused for the remainder of the hearing.
Any objections? Hearing none, granted.
Judge Mark Ellinger, on behalf of Nucor, would request to be excused for the remainder of the hearing.
No objections, granted.
Judge, same request for Google.
No objections, granted.
Judge Carl Zobrist, I'm not going to ask to be excused because this is far too much fun. I do just have, if the bench is in the mode of accepting other sort of administrative matters, I did discuss an opening statement the two old Missouri Public Service cases, and I don't know what your practice is, but they're certainly appropriate for the bench and the commission to take official notice or administrative notice of its prior rulings. And so I just want to formally offer the commission's report and order in case number EO-91-358 that was decided by the commission on December 20th, 1991. That was an AAO case for the coal the coal conversion and the life extension for Sibley. And then the rate case, it's number ER-90-101, and other cases decided October 5, 1990, where some of the seminal decisions with regard to the Sibley unit were also decided by the commission.
Okay. Do you have those prepared as an exhibit?
I do not have them as an exhibit. I have courtesy copies for you, Judge, and I'll bring those up. They have Westlaw sites, and that's going to be in our brief, so everybody, all the lawyers should have access to that, but I do have a copy for you, sir.
My point was the commission prefers exhibits over the taking notice of. Let's go ahead, because they are final decisions. Any objections to?
You want me to repeat it, Judge?
No. Okay. I'm looking for your next number.
135 and 136.
Any objections to the admission of Exhibit 135, which will be the commission's decision in EO-91-358? Question mark. Hearing none, so admitted.
You let me, sorry, I wasn't fast enough.
No, go ahead.
Not objecting, I just want to, these are the orders as available online through Lexis or something?
Correct.
Yeah, I have no
And-
objection.
Judge, and we'll provide copies in the morning, so.
Excellent. Last question, any objections to the admission of Exhibit 136 to be filed tomorrow, which is the commission's decision in ER-91-101?
90-101.
90-101. Hearing none, so admitted.
Judge Hatcher, in that vein, you had mentioned wanting, I believe, staff witness Cedric Cunningham,'s surrebuttal trip direct work papers. Would you like us to file that as an exhibit? And if so, can we just go ahead and see if parties would object to that now? They were all provided the work paper ahead of time, so it should.
Any objections to the work papers as described by Ms. Mers for tomorrow's exhibit for staff for Engineer Cunningham? What's your next number?
I believe it is 283.
On information and belief, any objections to Exhibit 283, which purports to be tomorrow Engineer Cunningham's work papers? Hearing none, so admitted.
Judge, Jim Fisher, the list we had 283 as the staff true-up rebuttal accounting schedules, but maybe that's incorrect.
I have 282 as the staff true-up.
I have 283.
Well, we can do 284.
Sold. And I'm looking on page 7, just for your reference tonight, not now during the hearing. But 283, staff true-up rebuttal accounting, that is underneath the true-up rebuttal testimony of Dr. Wan.
I apparently lost a page, so my apologies. 284 it is.
284, any objections? Hearing none. 284 is so admitted.
Your Honor, I have, I guess, in the same vein of asking for notice of report and orders, I can bring it as an exhibit tomorrow. Okay, I'll bring one.
Excellent. I can ask tonight, but it's going to be, tomorrow. Thank you. Let's see what business we have to wrap up.
I have one request of council. If it's sufficient for me to provide you the first page with the Westlaw or Lexis side, is that good enough, or do all the lawyers need to have full copies? Okay, good. And
would all the lawyers waive their copies for commission decisions? That would mean no copies for Evergy. That would mean no copies for MECG.
I would, as long as it is readily available in either EFIS or Westlaw. I do know with some of the older cases, as you may have heard Keith say in his struggle to look back, but some of the older cases are harder to find on EFIS. So as long as it is easily accessible, I have no issue for that. But if it's...
What about timeliness? Because I would say it's easily accessible after I admit it as an exhibit, but that might be while you're writing briefs.
Your Honor, can we agree to just email them copies to council?
Sold. Okay. We are down to announcements.
Would the court be amenable to pushing back the start an hour tomorrow? I said court, I meant commission, I apologize.
I appreciate the promotion. I'm looking at the schedule, and we have one issue, that is AMI, which for our listening audience is automation.
Advanced metering infrastructure.
Advanced metering infrastructure. I have on my list 6 witnesses. And we are discussing a 9:30 start time. I'm going to say no, only because we already have this all distributed and set up.
I understand. Say no more. Thank you.
Judge, just for my purposes, I have 5 witnesses. Do you have one more?
I have Lutz, Casely, Ives, Eubanks, Mark, Robinette.
Five.
I don't believe Mr. Ives is scheduled for tomorrow.
Okay, that might be one of the updates. I certainly might have missed that. So we're down to 5 witnesses. No, I would like to start at 8:30. We've all seen my luck with changing WebExes. Okay, let's talk. We only have the one issue tomorrow. I do not anticipate that taking all day. Any last announcements before we adjourn for the day? Excellent. I will see everyone and their exhibits tomorrow.
Thank you, Judge.
We are adjourned and off the record. Thank you.